Justice, where are you? Michael and Linda are here.
Love you, Linda.
The world is justice. Will we ever find justice?
The courthouse the other day in the hallway, you're singing
Will
"Oh
we
Happy
know
Day."
justice when we see it? To be endowed,
Council President Court, Council starting with the Commonwealth, kindly identify yourselves once again for the court and record.
Finding justice where we can. Join us now, we're on the run.
Good morning, Your Honor.
Justice is waiting, we'll see it done.
Good morning.
Morning, Your Honor. Larry Tipton for Mr. Walsh.
Good morning. We'll wait for Mr. Walsh, but while we're waiting, I'm just going to pass you out a couple of versions of something I want you to look at. I have a preference. I don't know how many copies that is, but I think it might be enough. If we need more, I have more. I just put that to the side, council, until we get there.
Thank you.
All right. Good morning, Mr. Walsh. I said good morning to everybody else, so good morning to you too. So since the version that I sent you at 1:55 p.m., I've made the following edits, either based on prompting by you or by my own accord. So on page 9, the use of a dangerous weapon is out. On page 17, the stipulation, separate instruction, I incorporated that into the evidence instruction. On page, it was on page 19. So what I did is I just added into page 19 some text. It's the second sentence. The evidence consists of the testimony of the witnesses, as you recall it. And then I just added in there the things that were marked as exhibits and the stipulation/agreements of the parties, rather than have it as a separate to-do. Just making it a little bit more streamlined. I edited out the last sentence of graphic photos instruction on page, I think it goes to the top of full page 18 as irrelevant to this case. And I also have removed the separate section later on page 18 about opinion testimony as repetitive of the expert testimony section above. On page old page. Now I can't find it right away. You may know where it is when you read through it. It says you'll have all the evidence with you. And I removed the non-relevant weapon and put in including the tools. But as I was thinking about that last night, mental note was, what does the Commonwealth, or how does the Commonwealth intend to safely put those tools? So what I've done in other places, or what I've seen done in other places, and it most often comes up in the context of a knife going back, I've seen other DA's offices basically take the knife and it's like they put it on a hard board and then they strap it down. So the jury can see the item but can't hurt themselves unwittingly with the item. It seems that the same could be done of the tools in this case, if you have the capability to do that. I think I've seen that done in Middlesex, Plymouth. That's how they sort of handle the issue. How are you planning on handling it?
We're working on it this morning, though.
Okay. So what I have in my mind, just so that, and I think law enforcement in the past has done it for the DA's office. So they may have the strapping mechanisms, but as long as I'm assured that they can go in safely to the jury deliberation room, either with a sheath cover on it, or preferably strapped down to a hard board, it seems to me that that would be a good approach. Anybody object to that?
No, Your Honor. We'll work with defense counsel, but we're trying to get some supplies to do that this morning.
All right.
We don't have any.
So I passed out to you two versions. I went back to look at different instructions I looked at a few different things, and this relates to the direct and indirect evidence instruction. And the version 1 is what I will call I put this in air quotes, I'll call it the Superior Court version of or what I most often see in the Superior Court, which is different than the District Court version, which is a little clunkier, I think. But anyway, you always like what you like, right? That is probably the more traditional, old-fashioned perhaps. As I read through it last night, I think it reads better than the version that I put into the first draft, but I don't have strong feelings about it. So if we have agreement between the parties as to which one you like better, I'm happy to read that. I think both of them are accurate representations of the law. I have a preference for version 1. Take a look at that and let me know when you've finished looking at them and have an opinion.
Your Honor, the Commonwealth doesn't take a position. Neither one seems
Fine.
viable.
Normally, honestly, I don't spend a lot of time on this in most cases but this case is one that I spent a little more time on it. Yes, Attorney Porges.
Your Honor, we're requesting version 2. So if no one else has a position, I'd ask the court read that.
All right, which is my version 1, I guess, right? It's the version that was in the instructions yesterday.
I believe so.
All right. Both are correct recitations of the law, so if you wish to draw from any of them, they're all good. And I'm not sure that they make a huge difference. All right. Any other edits to the draft instructions beyond those that I've just incorporated?
Your Honor, on page 12 of the 155 instruction on reaching a verdict, I believe there's some references for each charge, and I would suggest that that might have been a carryover to the plural version.
The 4-person,
I have page 12, reaching a verdict, the 3rd paragraph for each charge,
for the charge, yeah.
and then has proved every element of the charge beyond a reasonable doubt, then you should find that Mr. Walsh is guilty of the charge or just is guilty.
Okay.
In the next paragraph,
And same thing, particular?
yes, Your Honor, particular, and then the on that charge.
I'll just end it at not guilty.
Your Honor, on page 13, role of the jury, second paragraph. Do not be influenced by the nature of the,
Charge?
yes, Your Honor.
Mm-hmm. I think I already made that change. I just didn't tell you I did.
Your Honor, on page 31, alternate jurors, I believe there's a reference to 3, and I believe it's 4.
It is. I made that change later in the day too, and I didn't tell you about that either.
That's all the Commonwealth has identified, Your Honor. Thank you.
Anything additional from the defense?
No, Your Honor, content, except for the previous exceptions made.
Although now I think most of the previous exceptions you made have been removed,
Just being cautious.
but I get the point. All right, let me step off the bench quickly and make these changes. And the reason for that is I want you to each have a all to have a copy so that you can follow along while I'm doing it. It shouldn't take me very long.
All right.
Hey, welcome to Justice Served TV. Let me fix my official headroom there. Michel Bryant here. Linda Baden is dabbling in something and will join us when and if she can. So today, officially day 9. Not much of a day, though, in the Brian Walshe case. So we're going to talk about what is and what isn't. Also, that Charlie Kirk killer case, still grinding in Utah, but some very interesting stuff to come out of there as well. I think we, I don't know, should talk about all of it.
Justice, where are you? Michael and Linda are here.
I love you,
Where in
Linda.
the world is justice? Will we ever find justice?
The courthouse the other day in the hallway, you're singing
Will
"Oh
we
Happy
know
Day."
justice when we see it? To be and down, may I lead the way. Hoping justice will win the day. Listener clues, finding justice where we can. Join us now, we're on the run. Justice is waiting, we'll see it done.
Alrighty then. I feel like I just talked to you from the, oh, there's Domino. Domino's chiming in. He's been fed, so this is just, sometimes right after he's fed, it's he goes into ornery mode, like that. Anyway, yeah, so I've left the comfortable confines of the mobile studio to get into the home studio here, and see that big bauble hanging on Bonesy there? I'll have to grab that and play that one of these days before Christmas. It's this obnoxious Christmas ball that is animated and sings a song. Lisa, my wife this year, said that is not going on the Christmas tree. every year I'd put it on there because it's just perfectly annoying for the holiday. But this year it was banished to my office. And so there it is. Anyway, just because they've just wrapped up in Provo, Utah, in the case against the Charlie Kirk killer, I'm not going to say his name. I'm sick of it. Don't want to hear it. And it's just beginning. All kinds of issues about whether the camera's in the courtroom or not. It's not even a rip and read. It's more than that. So I'm not going to use our rip and read thing. Do we have a rip and read today? There was one thing. I think we did this during lunch. So I'm not sure technically it's officially as a new rip and read. But as we predicted last night, I think it was last night, when we were talking with Mizzy and Sandra Birchmore's second cousin, Barb, about this hearing supposedly coming up December 13th next week, in the Matthew Farwell case, a status, whatever that means, because it's been pushed and pushed and pushed. We do know that the AG has decided not to go after the death penalty about a month before they needed to make that decision. Well, that 16th date, that ain't happening. That's off. So there's some discovery going back and forth, mostly, would it be mostly back or mostly forth? The defense has not provided the feds with anything. The feds presented a list of tons of stuff they've provided over about 7 or 8 different dates. So they're obviously still hashing that out. And more importantly, what is happening with any potential co-conspirators, additional defendants? None of that is known. They pushed the date to, I believe it was the middle of February now, I think. So obviously we'll keep you posted on that as it continues to kind of roll very slowly forward. In court today, and back to the Walshe case now, surprise for everybody this morning, because there was some talk that really was as late as end of day yesterday and into the night, as far as the judge was concerned, that Brian Walshe was going to take the stand. And there were certain things she had to figure out in terms of what he could get into, what the protections might be for a defendant taking the stand in this situation. And so she, from her own description of it, kind of spent some hours working on this stuff, only to learn in the morning that, never mind. Brian Walshe not testifying, and his attorney, Larry Tipton, was like, I apologize. And she was very magnanimous about it. She could have been much more agitated, but she ultimately said, I hadn't looked at some of those issues in a while, so it was good to catch up on those. And she may have down deep been thinking, that's a hornet's nest, that if he doesn't want to testify, which is his right, great. That is something that's going to create many, many more issues during trial and certainly post-trial, right? So no Brian Walshe. And then the defense said, as a matter of fact, we got nothing. We got nada. We're not putting on an additional case other than cross-examining the prosecution witnesses. And I think if you look at the last couple of witnesses, which I was fortunate enough to be in the courtroom for, I think they did a lot of good for the defense. We talked about the reference to how depressed Brian Walshe was. We talked about the fact that nobody said that Brian Walshe knew about the affair, if you're looking for that as motive / therefore intent for murder one. So the defense is basically saying, I'm not putting on a case. They didn't put on anybody to argue about the sudden unexpected death or unexplained death. Remember Priya Banerjee, friend of the show, was on the witness list, didn't need her, didn't want to use her. And I'm sure it's because what we talked about late last week, when Dr. Atkinson, the medical examiner for the prosecution, on cross-exam laid out very clearly how common, may not be the right word, but less than rare is unexpected death. He said 5 to 10% of the deaths in somebody arguably healthy. And that's the key here. So that's out there. The jury can latch on to that if they want to. And they can say, well, not only did the prosecution not prove that there was intent to murder Anna Walshe, but there's the defense says it just happened unexpectedly, and there's evidence that could be the case. They could go that way. Now, on the other side of the ledger, of course, is what this guy did that they know about is despicable. The tools, the blood. We don't know how she died. We have no clue how she died. But him dumping off bags, all of those things could lead any juror to say, I'm not as happy as I'd like to be with intent, but I'm going that way. I'm finding it. I'm inferring it. And that's what the law allows. They can infer from the evidence that exists what they need to get to murder one. And then it's tough. It's tough to argue beyond that. It's in their brains. So somebody had asked earlier today during the lawyer lunch about putting on no defense and how that might lead to some sort of remedy for Brian Walshe. And I said, only in the context of an appeal based on Sixth Amendment right to counsel. Ineffective assistance of counsel, you could say, look, they put on no case. And I wanted to testify. They talked me out of it. Therefore, didn't get what I needed and therefore should have a new trial. It's an argument. It happens all the time. It is in the absence of really extreme negligence on the part of the attorney, malpractice. Very seldom does it win the day, but it's an argument that's made all the time. And I think defense attorneys get thick-skinned about it. They're Teflon. They're used to it coming. I think most who watch this trial, today was day 9, but let's face it, we had 8 days of trial plus jury selection. They would say that this defense team was pretty damn good, especially handed what looked like a miserable case from the start. Most people thought, before any evidence, just based on what was out there, that obviously this guy did it and it's going to be easy to prove. Well, he may have done it, but I don't know that they proved it, and I don't know that the evidence exists to prove it. You got to take your circumstantial evidence, twist it in a knot, tie it up in a package, and then, carry it over the line. I don't know that they did that, but it could happen. And on that point, I want to tell you what happened today when the jury was in their places with their bright, shiny faces. They came in ready to roll, a little after 9. And the first thing they hear is that, ladies and gentlemen, you heard the state rested yesterday. The defense has just rested now, so you're done. And I think there was some disappointment and maybe a little annoyance that they got all gussied up and they were there, in the morning. They'd rather maybe be somewhere else. But no grumbling, no audible complaints. And so they filed out. But before they did, the judge reinforced to this jury that, remember, it is the Commonwealth that has the burden. She did this in part because the jury had just heard the Walshe team say, we're not bringing any witnesses, and that's it. We're resting. So she wanted to make sure they were reminded that the defense has zero burden, no obligation of any kind to put on any sort of case. So I think doing that was important because of what had just unfolded in front of the jury. But what I was looking for in the jurors' body language, reception of that information, if it was just stone, cold nothingness, or if there was some indication that people were agreeing with what the court was reminding or disagreeing. Only one person making really any sort of gesture, and I've described it as like a metalhead, metalhead music where you're headbanging. Oh, yeah, that hurts my neck. I can't do that anymore. One guy in the middle, and I've got my cheat sheet here of juror information. And this is, I've said before that it's real weird the way the jury is broken down. You have one black African-American female, top row left. Haven't seen her do anything note-wise or anything, but she's there. And then we have an African-American male and a white male, and everybody else on the back row on the wall, the women. On the front row, you just have one guy smack in the middle, and he is surrounded by women, both white and African-American and not white. So the guy in the back, center row, again, this guy is, I'm going to say 30-ish, give or take. When the judge is reminding the jury about the burden on the Commonwealth, not on the defense, he was literally, I'm not going to exaggerate as I was before with my whiplash injury, but it was like this. It was that obvious. It wasn't a simple little, it was like adamant. Now, that guy may end up off the jury. Remember, 4 people have got to go. But gives you a sense of what at least one person, unless it was, it was so obvious. I really thought it was like a twitch. Like a Tourette's kind of, it was aggressive. But I remember during the whole trial, this guy was not noticeable. It wasn't like he had that affect all through the trial. It was purposeful. If he's on the jury and he makes the final 12, I think it's an issue. Well, maybe not. Maybe he was just being, agreeable, eye contact with the judge. And he was just, like encouraging her. Thank you. Thank you for telling us. Appreciate that. He's still going down. I mean, who knows what's going on in his head, but I just thought that was very interesting. And somebody was asking earlier too, I didn't have this with me. I somehow left this. That's me. I left it behind. And I think I said there were 5 male because I got that confused with non-white versus white. 5 non-white, 11 white, 9 female, 7 male. So it is a primarily female jury. As it's constructed right now, that number could tip either more female oriented or get closer to even, depending on who the 4 that are bounced might be. So the other thing we're going to talk about today, just because I think it's important with this Charlie Kirk killer case that just wrapped up in Utah, is media access, those issues that, you think some of the cases we've talked about have, issues. Man, this case has issues. And it's not about the guilt or innocence. It's all procedural crap. The media, what they can do, what they can't do. There's a gag order in place, and the judge reinforced that today. So the parties, either side, and their experts, anybody that is retained by either side, not precipient witnesses, because they've estimated they have 3,000 potential witnesses. That would be all the folks that were on the campus that day, the day of the shooting of Charlie Kirk 3 months ago now. Obviously, they can't be gagged. That might be a little bit of an overreach. But if you're already affiliated with or become affiliated with one of the teams, then you were covered by that gag order as well. So no spouting off to the press. And I guess there have been, I don't really traffic in this stuff, but I guess there have been a lot of conspiracy theories and stories that are out there that people can't get information, so they kind of make up their own stories, and they've been promoting those on various outlets or channels or whatever. Again, I don't traffic in that, so I don't know who's saying it or what they're saying. But problem with the gag order is that kind of stuff might be more likely to proliferate, because what do you got? You don't have the facts. You don't have the real info. Let's just make some shit up, and it'll happen. I guarantee you it will happen. And I think we're seeing it already, and the court's aware of it. Let's do this. Because this just ended, and I'm so fascinated by what they're doing in Utah with regard to cameras in the courtroom, and I think I know exactly what happened when this came up today. Okay, so they allowed the cameras in, and it was weird because the first thing they did was the judge said, and this is Judge Tony Graff, and I got some thoughts on the tone, but they said, we're going to have this hearing. Part of it's going to be a closed session. And that had to do with the release of a transcript and the recording from, I think it's an October 24th hearing in this case that was locked up. It hadn't been released. So they were having a hearing about whether to release the information from the hearing that wasn't held in the public the first time. That I got a problem with that anyway. They say it had to do a lot with security issues. Okay, fine. I understand that. If you have a security plan, you don't want to be broadcasting that. I get that. But otherwise, let us in. And that's what bothered me. In that session today, they locked out everybody. Not just turned off the cameras, locked people out like it was a minor's hearing or some sort of hearing that is normally a closed session. This is not dealing with a minor. This is an issue of international interest, not just...
All right, all set? Good.
All rise. Jurors entering. Hear ye, hear ye, hear ye. All persons having anything to do for the Honorable Justice Diane Fournier, Justice of the Norfolk Superior Court, draw near, give your attendance, and you shall be heard. Such are the Commonwealth of Massachusetts in this honorable court. Please be seated. Please turn up your cell phones.
Jurors, and welcome back to the courthouse. Jurors, will start today as we have every day together with the 4 questions. Jurors, were you able to comply with my order that you not be on any social media or any news media?
Yes.
Yes.
And were you able to comply with my order that you not do any research about this case?
Yes.
Are we able to comply with my order that you not speak to anyone about this case?
Yes.
And do you all still have open minds?
Yes.
Those 4 answers for the record all answered affirmatively by all 16 jurors in the box. We're ready to begin today's work. So as I promised yesterday, jurors, there's 2 chapters that will come interspersed now as we start today. And those chapters are that I will give you the instructions that are specific to the charge of murder here in this case. Then the parties will do their closing arguments. And then depending on how you're doing, given the time that's passed since then, we may have a short break, a bathroom break. Then I'll come back and give you the more generalized instructions on the law. Deliberately break it into 2 chunks. It's more consumable for you that way. The jurors, I want to thank you for your service on this jury. To a person, when I've looked over, you've caught me many times looking over at you. You've been paying attention, and that's exactly what I anticipated. But it's refreshing and rewarding for me to see it. So I know that you have paid attention to the evidence in this case, and I appreciate your attention. Your jury service in this case is a very important part of our democratic self-government. You are responsible to uphold the law and our principles of justice. That's what you promised to do at the start of this trial when you took an oath as a juror. You've all devoted a substantial period of time on this case, time away from your personal lives, your work, studies, your families, to sit as jurors in this case and to decide the very important matter, an issue now between the Commonwealth and the defendant, Brian Walshe. You've done so in accordance with the finest traditions and the highest aspirations of our system of justice. Again, I thank you for your service and your sacrifice. You must now consider all of the evidence, decide who and what to believe, and decide whether the prosecution has proved beyond a reasonable doubt that Mr. Walshe is guilty of the crime of murder. The final part of this trial, as I said, will take place in those 3 steps. First, I'll give you on the law that is specific to the charge in this case. Then the attorneys will make their closing arguments, in which they will highlight the evidence that they think is important and will argue in favor of the conclusions that they ask you to make. Defense attorney, Attorney Tipton, will argue first, and the prosecutor, Assistant District Attorney Yaz, will argue last. After the closing arguments, again, I'll give you those generalized instructions that will help guide your evaluation of the evidence and your decision-making and your deliberations as jurors. And then you will work together to reach a unanimous verdict. Please pay careful attention to all of my instructions. All of my instructions are important and you must follow them, whether you agree with them or you do not. To make sure that I give you the instructions accurately, you can see that I'm generally reading them to you. You will also get written copies of the jury charge, the jury instructions, in the jury room when you deliberate the case. I do my best to make sure that the instructions that I'm giving you while I'm speaking match these written instructions. If there is any difference between what I say aloud and the written instructions, please follow what I say aloud. So let me start with the prosecution's burden of proof, and I'll start with the presumption of innocence. There is a fundamental rule that applies in all criminal cases, including this case. Every person who is accused of a crime is presumed to be innocent of that crime. Mr. Walshe is presumed to be innocent of the charge in this case. That means that you must consider Mr. Walshe to be innocent unless the prosecution has proved beyond a reasonable doubt through evidence presented at the trial that Mr. Walshe committed the crime charged. And I will explain what I mean by reasonable doubt in a minute. Mr. Walshe does not have to do anything to convince you he is innocent. He does not have to explain anything to the jury. Mr. Walshe does not have to testify, call or question witnesses, or provide any evidence at all because you must presume he is innocent. Instead, it is up to the Commonwealth to prove the charge against Mr. Walshe beyond a reasonable doubt. This burden of proof never shifts to the defendant. After you have considered all of the evidence carefully and fairly, if you have a reasonable doubt about Mr. Walsh's guilt on the charge of murder, then your verdict must be not guilty. You may find Mr. Walshe guilty of the charge of murder only if all 12 deliberating jurors agree that the Commonwealth has proved the charge beyond a reasonable doubt. So the burden is on the Commonwealth to prove beyond a reasonable doubt that Mr. Walshe is guilty of the charge made against him. What is proof beyond a reasonable doubt? The term is often used and probably pretty well understood, though not easily defined. Proof beyond a reasonable doubt does not mean proof beyond all possible doubt, or everything in the lives of human beings is open to some possible or imaginary doubt. A charge is proof beyond a reasonable doubt if, after you have compared and considered all of the evidence, you have in your minds an abiding conviction to a moral certainty that the charge is true. When we refer to moral certainty, we mean the highest degree of certainty possible in matters relating to human affairs, based solely on the evidence that has been put before you in this case. I've told you that every person is presumed to be innocent until he or she is proved guilty, and that the burden is on the prosecutor. If you evaluate all of the evidence and you still have a reasonable doubt remaining, the defendant is entitled to the benefit of that doubt and must be acquitted. It is not enough for the Commonwealth to establish a probability, even a strong probability, that the defendant is more likely to be guilty than not guilty. That is not enough. Instead, the evidence must convince you of the defendant's guilt to a reasonable and moral certainty, a certainty that convinces your understanding and satisfies your reason and judgment as jurors who are sworn to act conscientiously on the evidence. That's what I mean by proof beyond a reasonable doubt. There's one indictment or charge in this case. You must decide whether Mr. Walshe is guilty of that charge. For the charge of murder, there are certain things, we call them elements, that the Commonwealth must prove beyond a reasonable doubt to show Mr. Walshe is guilty. I will explain these legal rules to you now. There are two different degrees of murder. Murder in the first degree and murder in the second degree. If you find the defendant guilty of murder, you shall decide the degree of murder. Commonwealth alleges that the defendant committed murder in the first degree on a theory of deliberate premeditation. To find the defendant guilty on this theory of murder, you must be unanimous. That is, all of the deliberating jurors must agree that the Commonwealth has met its burden of proving every element of this theory beyond a reasonable doubt. If you are unable to agree unanimously that the Commonwealth has met its burden to prove beyond a reasonable doubt this theory of first-degree murder, you shall consider whether the Commonwealth has proved the defendant guilty beyond a reasonable doubt of murder in the second degree. I'll begin by instructing you now on the elements and the additional requirements for the proof of murder in the first degree with deliberate premeditation, and then I will next instruct you on murder in the second degree. Murder with deliberate premeditation. To prove the defendant guilty of murder in the first degree with deliberate premeditation, the Commonwealth must prove beyond a reasonable doubt the following three elements. First, that the defendant caused the death of Anna Walshe. Second, that the defendant intended to kill Anna Walshe. That is, the defendant consciously and purposefully caused Anna Walsh's death. And third, the defendant committed the killing with deliberate premeditation. That is, he decided to kill after a period of reflection. I will now discuss each of those requirements in more detail. The first element is that the defendant caused the death of Anna Walshe. A defendant's act is the cause of death where the act in a natural and continuous sequence results in death, and without which death would not have occurred. The second element that the defendant intended to kill Anna Walshe. That is, the defendant consciously and purposefully intended to cause Anna Walsh's death. The third element is that the defendant committed the killing with deliberate premeditation. That is, he decided to kill after a period of reflection. Deliberate premeditation does not require any particular length of time of reflection. A decision to kill may be formed over a period of days, hours, or even a few seconds. The key is the sequence of the thought process. First, the consideration whether to kill. Second, the decision to kill. And third, the killing arising from that decision. There is no deliberate premeditation where the action is taken so quickly that a defendant takes no time to reflect on the action and then decides to do it. Murder in the second degree. In order to prove murder in the second degree, the Commonwealth must prove the following elements. First, that the defendant caused the death of Anna Walshe. Second, that the defendant A, intended to kill Anna Walshe, or B, intended to cause grievous bodily harm to Anna Walshe, or C, intended to do an act which, in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result. I will now discuss each of these requirements in more detail. The first element is that the defendant caused the death of Anna Walshe. The defendant's act is the cause of death. The act, in a natural and continuous sequence, results in death, and without which death would not have occurred. As you can see, the second element has three sub-elements, which I'll call prongs. And the Commonwealth satisfies its burden of proof if it proves any one of the three prongs beyond a reasonable doubt. The first prong, the defendant intended to kill, is the same as the second element of murder in the first degree with deliberate premeditation. The second and third prongs are different from any element of murder in the first degree with deliberate premeditation. The second prong is that the defendant intended to cause grievous bodily harm to Anna Walshe. Grievous bodily harm means severe injury to the body. The third prong is that the defendant intended to do an act which, in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result. Let me help you understand how to analyze this third prong. You must first determine whether the defendant intended to perform the act that caused the victim's death. If you find that he intended to perform the act, you must then determine what the defendant himself actually knew about the relevant circumstances at the time he acted. Then you must determine whether, under the circumstances known to the defendant, a reasonable person would have known that the act intended by the defendant created a plain and strong likelihood that death would result. Let me give you some supplemental instructions relevant to the charge of murder. The definition of death. Death occurs when the heart has stopped long enough to result in complete and permanent loss of brain function. This complete and permanent loss of brain function occurs when, in the opinion of a licensed physician based on ordinary and acceptable standards of medical practice, there's been a total and irreversible cessation of spontaneous brain functions, and further attempts at resuscitation or continued supportive maintenance would not be successful in restoring such function. Next, the jury's obligation on guilt or innocence. You've been instructed on two theories of homicide in this case: murder in the first degree and murder in the second degree. If the evidence convinces you beyond a reasonable doubt that the defendant is guilty of a criminal offense, you have a duty to find the defendant guilty of the most serious offense that the Commonwealth has proved beyond a reasonable doubt. If the evidence does not prove beyond a reasonable doubt that the defendant is guilty of any offense charged, you must find him not guilty. Do either counsel need to see me?
No, Your Honor.
Be happy to see you. You take the, I know you haven't been sitting there that long, but you're going to go for a stretch now. So I'm going to ask you to stand up. And, as I've said to you before, shake a leg. When you're ready, please be seated. So jurors, I'm about to conclude my first set of the instructions to you, and we're going to hear the closing arguments of counsel next. This is an important part of the trial because it's the final opportunity that the lawyers have to address you. It's an opportunity for the lawyers to summarize the evidence, to call your attention to certain parts of the evidence that they regard as important, and based on the evidence, to try to persuade you to reach a certain result. However, what you're about to hear is not evidence. Lawyers aren't witnesses. All of the evidence in this case has been presented to you through the testimony of the witnesses, the exhibits, stipulations, which you have before you. As to the exhibits, you'll have an opportunity to examine those in detail and consider them during your deliberations. Our rules are designed to ensure that the parties receive a fair trial, and they therefore prohibit the attorneys from making certain types of arguments in an effort to persuade you to reach a certain result or to favor or discredit either party. For example, the lawyers are not permitted to refer to facts that are not in evidence in this case. If, based on your memory and understanding of the evidence, a lawyer does this, you should disregard that comment. The attorneys are not permitted to express their personal beliefs in the credibility or lack of credibility of any witness who testified in this case. That determination is entirely for you to make. If a lawyer makes such a comment, you should disregard that comment. This case must be decided based solely on the basis of the admissible evidence and the law that I'm teaching to you. Attorneys are not permitted to persuade you for or against either party by appealing to human passions or prejudices. If a lawyer makes such a comment, you should disregard that comment. If you become conscious of any passion or prejudice as you consider the evidence and engage in your deliberations, you must put these feelings aside and not permit them to influence your thinking. With that, we'll turn to the closing arguments. As is the custom, we'll hear first from the defense. Attorney Tipton.
What could happen to a loving father and a loving husband?
We're making line of police before they search for the unspeakable on the internet. Exposed body of the woman that you adore. Governments suggest it was an affair. There's no proof of that. There's no proof that Brian Walshe knew anything about an affair between the woman he loved and William Tesler. Money? Second reason that the government suggests, family money? Money that the family had worked together for years and continued to talk about in text messages and the sales of property, trying to protect the assets for the benefit of the whole family and the future of their 3 children. A motive? There's no motive. Refusal to consider prison for a terrible mistake he made. The case that began in 2018. There's no proof of that. that he was afraid to go to prison. Who wants to go to prison? But prison was always on the table. And it was just something that he had to face up to, and something that he did. So, what would cause a loving husband and a loving father to do the things that you heard about in this case? Could it be something that was sudden, something that was unexpected, something that was unbelievable, something that only a medical examiner would understand, have knowledge of, but not a man like Brian Walshe? Something that is terrifying, something that defies logic when it happens. How do we know that Mr. Walshe was a loving father and a loving husband? We know from much of the testimony of Jim Mutlow. We know from simple testimony from Julie Basler from Kindercare. When asked questions about her experience with Mr. Walshe and the children, that he would show up and he'd be interested and he'd be friendly, and he was always interested in the progress of his children. And how do we know he was a good father? Because Anna Walshe trusted him with their 3 children, 24 hours a day, 7 days a week, for all those times she was up in Washington, D.C. The unthinkable happens. It happens in a variety of ways. And the Commonwealth must prove to you beyond a reasonable doubt that a homicide occurred, that a killing occurred. Nothing proves that beyond a reasonable doubt on the facts and circumstances and the evidence given to you. There's evidence that he lied to the police. There's evidence that he searched the internet. There's evidence that he disposed of a body. But there is no proof in all of the evidence that you have heard and been presented that he ever once thought about harming the woman he loved. That he ever thought about harming the woman he loved. Did he ever planned to harm? Did he ever intended to harm? So, when we talk about the evidence of the affair, when we talk about evidence of financial concerns, when we talk about evidence of being ready to go to prison, those are the motives that the Commonwealth needs to prove to you to support any notion that a loving husband and a loving father would kill his wife. And the evidence suggests there was no motive at all. And without a motive, without a reason that is based on facts and circumstances, logic and understanding, without that, you have a sudden and unexpected event that results in confusion, and panic, and fear. All of those things that are so troubling and horrific that you've heard evidence about, they may be argued that they show consciousness of guilt. But people do things, terrible things sometimes, not out of guilt, but out of fear, out of disbelief, out of confusion. Certainly, a loving father and a loving husband would feel guilty about what he did do. Not just about lying to the police, but what he did do in the context of what he did to the woman he loved. In a moment, in hours, and in days of confusion and disbelief and horror. But that feeling of guilt had nothing to do with the killing, because he never killed Anna Walshe. You will hear arguments, but you've seen the evidence that might evoke emotion. Who wouldn't feel emotional in what you've heard, what you've seen? But your obligation, and I don't mean to sound like I'm lecturing you at all. Her Honor will instruct you on the law, and that is not my province, but you cannot base your verdict on sympathy for Anna Walshe. You can't base your verdict on anger to what Mr. Walshe did. You can't base your verdict on passion, based on the evidence that you've heard that is upsetting and terrifying and at times disgusting. But that's not what you can do as jurors in this case. At the beginning of this case, when you were sworn as jurors, you might not recall it, but the clerk of this court read you some words. To this indictment, the defendant pleads not guilty. He places himself before this country which you are, the obligation that you have accepted in this case is unlike perhaps any obligation that you've ever accepted in your life. Perhaps. That's for you to judge. But your obligation requires that without passion and without anger and without sympathy, that you assess the facts as troubling as they are, and at times as horrific as they are, and make your verdict rest on the evidence, and nothing less and nothing more. Unbelievable, facts that don't make sense at times, something that is incongruent. An example of that is the end of Mr. Jim Mutlow's testimony, where for almost an hour, he talked beautifully about the love between these two people. That he talked glowingly about Mr. Walshe. And then toward the end of his examination, he wanted to say something about now he was thinking there might have been some kind of problem. And reflect upon the evidence that he gave of a phone call he had with Mr. Walshe on the 4th, when the conversation was confusing to Mr. Mutlow, confusing where he kept asking what could have happened that would result in Anna Walshe leaving. The lie that Mr. Walshe was telling people out of fear that no one was going to believe him about what happened, so he lied. But consider the way that Mr. Mutlow had a terrible time trying to understand that. And why? Because he knew both of them. Because what he was thinking, why would Anna Walshe leave? They love each other. I know them both. It makes no sense. And that is what happens when something happens that is totally confusing. You just can't believe it. And you seek answers. You yearn for answers that make sense of something. And when something sudden and unexpected happens, something tragic, your ability to come to terms with it when it's such a dynamic, such a tragedy, you change. You change. The evidence of the searches, the dark, troubling evidence of the searches. They began at 4:52 a.m. on January 1st of 2023. And the first one is, how do you dispose of a body? It causes chills. It causes disgust. Look at all of those searches. Think of how they evolved. Consider how they go from one subject to another in rapid fashion. Searches conducted by a man that is in disbelief, in confusion. 5 hours spending with his wife on New Year's Eve, enjoying life, talking about the future. And then the sudden and unexpected tragedy happens, and it doesn't make sense. If Mr. Walshe began to make those searches with murder in his heart as a result of murder, then why isn't the first search how to dispose of a body after murder? Because that's the search that occurred 6 hours later. And when you see that word murder, no one would not react to that word. And certainly as jurors in this matter, you're expected to react in a way to that. What does that mean? Does that mean that he in fact murdered his wife? But think about it in context. In this case, on these facts, context matters. And so the first time the word murder is used in these horrific searches is 6 hours after they began. And I tried to ask Trooper Garino, one of the forensic specialists, as he called himself, associated with the Mass State Police. I tried to ask him, well, it's only logical, isn't it, that if you don't get results, you change the wording. We all know that from our own common experience. And you look at those searches that came and went during this time, and the results had to do with funeral parlors and cemeteries and things like that. But Mr. Walshe, given the tragedy that occurred to his wife, and given the time that had passed and his fear and disbelief, he couldn't call a funeral parlor. You need to try to understand, what can I do? Then the searches become darker. They become more upsetting. Now the thought is dismemberment. And there's searches like that. You've heard about them. You'll read about them. And then you see searches that cover days. And there's searches about cleaning. And there's searches about how to clean up. You'll read them. And even though they don't talk about murder, they are equally upsetting, because you're thinking, as jurors in this case, he's thinking about cleaning up the basement. He's thinking about how you clean a concrete floor. Context. 1,034 pages of digital data, 3,667 records taken from his MacBook. Not one record, not one page refers to any plan. Not one record, not one page refers to any intent to kill. Nothing. So keep it in context when you review that exhibit and those searches and ask yourself, why is a man searching now if he had intended to kill his wife? Why is the man searching now if he had planned to kill his wife? And that is the government's theory. He planned. He deliberately premeditated the plan to kill his wife. Where is the evidence of premeditation? In thousands of pages of records. I suggest to you respectfully, you're the jurors. What is the evidence of premeditation? There's evidence of a knife. There's evidence of a knife that is seen in a kitchen cabinet. Could I please have exhibit 201? And next exhibit 202. And finally exhibit 203. The knife. It was above a refrigerator. It was in plain view. Had no visual red blood stain. And yet the government wants you to think about this knife. So think about it. Don't ignore it. Do not refuse to consider it. Of course you will, but think about it. In a cabinet above a refrigerator. And they first test it with some screening test. It doesn't prove that it has even blood on it. And they take it, and they should. And then, what happens is everybody loses interest with the knife. Everybody, the Mass State Police, the crime lab. There's no further testing of this knife. And ask yourself, if that knife is to be considered a weapon used, then why is it in that cabinet? You have heard evidence of bags and bags being thrown in dumpsters over a period of days. The government wants you to think that Mr. Walshe killed his wife and perhaps used this knife. Then why was it sitting in a cabinet days later in open view for the police? What logic is that? And there is no proof that it had one piece of biological evidence on it tied to any killing or any harm. And they simply lost interest in it. You can take it down now. Digital data, talked about that briefly, but there is nothing in that data. All of that data. And we're talking about text messages. We're talking about backbook searches. We're talking about the life that's embodied in computers that this day and age we know apparently keep track of everything we do and to some extent everything we think about. Because that's how the government is using that data. They ask you to look at certain things and indicate and try to argue that, oh, this is what he was thinking. So look at it and judge for yourself. What's in this data that demonstrates premeditation or intent to kill or intent to harm? You have heard and seen much physical evidence. You've seen pictures of gray slippers with blood on. You've seen pictures of all kinds of physical evidence. And if the argument is made by the government, something about a dark gray slipper with blood on it indicates that a murder happened because, listen to the argument, of course you will. But a theory, an opinion, does not make it true. And to suggest something like, the evidence shows that Mr. Walshe went and bought a Tyvek suit and maybe there's just not enough blood on the Tyvek suit to satisfy the Commonwealth. And so they suggest that some killing happened. And that's why there's so much blood on that slipper and those slippers and all that other evidence. But ask yourself, what do I know about that evidence now from what we heard? Every piece of evidence was put into a bag that then was put into a compactor eventually and was pressed together and then found. And you will see all of this evidence of when they pulled it out of dumpsters and unloaded the bags, and they first put it on damp ground without any paper below it, without any tarp below it. And you heard from no less than 3 witnesses. Mr. Gould from the Mass State Police Crime Lab, Mr. Sheehan from the Mass State Police Crime Lab, and Ms. Celine from the DNA unit. They all consistently said cross-contamination or transfer. They used different terms, but they all agreed. So the evidence, the physical aspect of the evidence, the thing you see in the photographs, the thing you see now, if you open up one of the bags and take things out, is not representative, or may not be representative, of how it looked before. And you must consider that. So when the government makes an argument based on the state of the physical evidence as it appears now, ask yourself, maybe that makes sense, but maybe there's another way of thinking about it. And why is that important to your deliberations? Because you are allowed to rely on what's called circumstantial evidence. You're allowed to rely on inferences. And Her Honor will instruct you on that. I will not. But whatever reason and basis you have for making your choice and determining your decision must be reasonable. And if you, as jurors, talking amongst yourselves, find that some of your fellow jurors say, well, I think maybe it means this, and I believe this, and your other jurors, fellow jurors, say, I think this, and I believe this, you'll all consider it. But if you don't agree, then you have to ask yourself, is that inference reasonable? Is that circumstantial evidence built upon inference? Is that reasonable? And can I use that? And should I use that to try to reach a verdict under a standard of reasonable doubt or moral certainty? What is the evidence that something violent happened in this house? I went through every room as best I could with Mr. Sheehan. There was nothing found in the upstairs bedroom. There was nothing found in the sinks and basins, showers of multiple bathrooms. Nothing found, meaning biological evidence that might indicate something violent occurred. There was nothing found in the kitchen other than a knife that they lost interest in. There was nothing found in the living room that had padding around the fireplace to protect the children from falling. There was nothing in that bedroom where Anna Walshe, Brian Walshe, as adults, enjoyed their life together and had spent their life together, perhaps every night, before she moved to D.C. to take that job. And how do we know that? We know that because the photographs show there was nothing there. Even what was characterized as red-brown stains on curtains in the bedroom turned out not to be blood at all. We know that because trained examiners from the Mass State Police examined probably every square inch of that house. We know that because we saw photographs and heard testimony about floor that was dug up based on their experience and training. That biological evidence, like blood, can fall between the cracks of flooring and reside on the subfloor. And so they tore the floor up, and you saw those photographs, and you'll have them. And nothing was found. Nothing at all. I asked Mr. Sheehan about blood spatter, and he forthrightly and honestly said, I'm not a blood spatter expert, but he explained it sufficiently to you. Someone wielding a knife or a weapon and causes blood to let out of a body, and you look for blood that has spattered with directionality. Nothing. Nothing in the bedroom, nothing in the living room, nothing in the bathrooms. No evidence that blood drained down the drains. Could I have Exhibit 217, please? That test that I asked Mr. Sheehan about, the Serotek Hem test, that checks for hemoglobin, for blood, that test, he agreed, can detect blood at the sensitivity of 20 nanograms per milliliter. 20 nanograms. A nanogram, as he agreed, 1/billionth of a gram. Think of how minuscule that is. And they used that all over the house. And so the government elicited questions and answers from many of their state police, the 10 or 20. They didn't call everybody. That's up to them. But apparently there was no need to, because 10 people or more, as Mr. Sheehan had described to you, he was estimating. He was trying to be as honest as he could and credible, and he was. 10 people pouring over that house all day on January 8th. 10 more people or more pouring over that house on January 9th with their tools and their experience, and they don't find anything except multiple bloodstains where? In the basement. In the basement. On the concrete floor. Ask yourself, when you heard testimony that Mr. Walshe attempted to clean, and so therefore they couldn't find evidence in the other parts of the house because he cleaned it. Well, ask yourself, wait a minute. Is that logical to suggest that he cleaned the bedroom up so well nobody could find a thing? He cleaned the living room up where the rug may have been, and they couldn't find anything. Well, then you see those searches where he searches specifically for how to clean concrete. So you might infer, and it might be a reasonable inference, that he attempted to clean that concrete floor. And yet, what was found on the concrete floor? Multiple red-brown stains that turned out to be blood. And in some instances, we can all agree, based on the testimony of Ms. Salim, the profile of those blood drops matched the profile of Anna Walshe. So to suggest that Mr. Walshe did everything he could to clean the basement concrete floor with hydrogen peroxide and mops and cleaning fluids, only to have blood found on the floor, defies a reasonable inference that he was able to clean any part of that house sufficiently to avoid detection. And why is that important? Because nothing violent happened in that house, And that's why there is no biological or blood evidence anywhere in that house. The act of trying to hide the body of his wife and the blood evidence that is seen on that carpet. That's what happened. There's no blood in the living room. The inference might be that the carpet was taken downstairs. Because you can look at those pictures. You can look at the physical pieces of carpet. You should. If there is no evidence of any killing that happened, and there's no evidence that anything was done before Mrs. Walshe died, and there's no evidence of premeditation or anything, there is evidence of lying and disposing of the body. You can take that to one statement. So now we look at the evidence, and I'm just going to characterize it. Some of the evidence that the Commonwealth has presented to you, and there is no question that their obligation is to present to you evidence. But I just ask you to think about, in some cases, how that evidence was presented to you. And I'm going to use a phrase that may or may not be entirely accurate, but it's cherry picking. It's looking at thousands of points of data and asking you to think about it, but not telling you why you should think about it. And what am I talking about specifically? And I'll give you some examples. We already talked about the hole in the ceiling, but let's talk about it a minute. They kept talking to you about that hole in the bedroom ceiling as if it was of some significance. And yet you recall the testimony of Mr. Sheehan. I didn't see anything significant about it. It looked like somebody might have fallen through the ceiling. And there's nothing significant about the pieces that Mr. Walshe had stored in the cabinet in that same bedroom. I asked Mr. Sheehan about that. No, I didn't see anything significant about that. Yet you kept being given that evidence. And then as the evidence developed, for some reason, there's Mr. Murphy. And it came out in evidence that Mr. Murphy had in fact contacted Mr. Walshe because there was a promotion going on. It wasn't that Mr. Walshe said, hey, come and fix this hole, this suspicious hole. No, he was contacted. And he didn't respond right away, but then he did. And for some reason, they keep insisting that that hole is of some significance, but they don't tell you why, they just give it to you. They do the same thing with the searches. Remember when Trooper Peef was sitting right here and he's asked to look through those thousands of, 250 pages of the search history from the iPhone Mini 13, the phone that belonged to Mr. Walshe, and he's asked to look at it and says, do you see searches there to go to the MGM? Yes, I do. Nothing else. No explanation why that is significant, why it's important to try to determine if a man committed premeditated murder. You're just throwing out pieces of evidence. Why? Why were you given, why was Trooper Peef asked to tell you about a song, a partial song title? And when you go over that evidence, look through there if you choose to, and I will encourage you to do that. And you see song after song and movie title after movie title. Why is it that the government throws that at you and says, think about this? For what reason? And then they present to you through Trooper Garino something about a porn movie. I'll just take this opportunity right now to apologize to each and every one of you for some of the questions I asked. But it just didn't make sense that you would take that type of evidence and suggest that it has anything to do with determining whether someone committed deliberate, premeditated murder because there's a word in the title of a movie. And that's what I'm talking about, the quality of some of the evidence here, thrown at you as if it means something, that it's significant, and yet here you are being asked to determine if someone, Mr. Walshe, committed premeditated murder with a specific intent to kill the woman he loved. When we talk about premeditated murder, we talk about planning, you have to ask yourself, did I hear evidence of the conduct of a man who premeditated, a man that had thought about a killing, a man that had planned? I mean, think about what you heard. And we're not going to repeat all these things I've already said, but I want you to focus on one other piece of evidence. I asked Detective Schmidt, when you went down to the basement on January 4th, you saw some bags down in the basement. Yes, I did. What did you think was in those bags? I thought they were pieces of rug. My goodness. What does that tell you about the thinking process and the sloppiness and the lack of any planning or careful thought that you would expect out of someone who had planned a murder? And then he lets a police officer walk down in the basement, and the police officer, based on his training and experience, uses, I think he said, his boot, and he felt it, and he said, felt like pieces of rug to me. Rug that is in evidence that has blood. Think about all of that when you're thinking about it. Did this man, Mr. Walshe, did he plan anything? No. Did he intend to kill anybody? No. Did he kill Anna Walshe? No. The evidence does not support a finding of premeditated murder with specific intent to kill based on the evidence, not based on sympathy, based on the evidence. What's some other evidence that is troubling? Mr. Walshe is talking to the police, and he says, I messenger. When asked about, and we was trying to explain it, things will come up on my phone that I thought were for me, but then it turns out they were for Anna. And so the government seizes upon that evidence and suggests that there's evidence that Mr. Walshe had seen text messages between Anna Walshe and William Fastow. And those text messages between Anna Walshe and William Fastow, some text messages are placed into evidence, and I'm sure you'll look at them. And why would the government want you to believe that Mr. Walshe saw those text messages? Because some of the entries in those text messages are very upsetting. They may very well enrage a husband to read about what was going on in those text messages. So you'll look at them, but ask yourself, as you look at them, and perhaps as you think, I could see that might upset, that might put somebody in a rage. Problem is, there is absolutely no evidence Mr. Walshe ever saw any text message, because he was trying to say, I messenger. And now you know from the testimony of Trooper Keefe, there's no such thing as I messenger. We're talking about Facebook Messenger. But the important thing is, there is no evidence in all of the digital data that you have before you, in all the digital data that they examined, that Mr. Walshe ever saw anything going on between his wife and William Fastow. And when you look at those text messages, and you might have some question about it, and if the government stands up and says, well, he saw those because he told them that he was seeing iMessenger, which doesn't exist, then ask yourself, why is it then that on New Year's Eve, Anna Walshe is taking all these photographs? It's festive. It's a lovely situation. And she says, in the presence of Brian Walshe, as she and Jim Mutlow were taking photographs, hey, why don't we send a photograph to Will Fastow? And was there any evidence that he reacted, Mr. Walshe? No. And when asked by Attorney Porges, well, so what happened next? And Mr. Mutlow really took efforts to remember, and then he said, oh yeah, that happened around before the young boy woke up and came downstairs, and that was around 10:30. So if you just think about that, then the festive and jovial celebration continued for another 2 hours. There is no evidence that he reacted. Mr. Walshe reacted to them sending a photo. Why? Because he knew his wife had a crush on Will Fastow, and it didn't even make him jealous. And how do we know that? Because she told her friend, Alyssa Kirby. And Alyssa Kirby was asked, and she said, you know, Anna told me that he didn't get jealous. He's not the jealous type. In fact, I wish he was more jealous. Please consider that in the context of this notion that the motive for a killing that did not occur, but the Commonwealth's theory of a motive is anger over an affair. There's no evidence of that. Dr. Atkinson told you. Dr. Atkinson described to you the phenomenon of sudden unexpected death. It happens. And just because it's rare, and just because the government will undoubtedly argue that that is nonsense, listen to their argument. But Dr. Atkinson made it clear it happens. It happens in young and old, male and female. It happens unexpectedly. In fact, it happens with people who have never manifested any problem before. It happens in athletes. And how do we know that it's not absurd, even though it might be rare? How do we know it is an important aspect of what happens to people? Because the laws of this state mandate that the office, the chief medical examiner, get information from doctors, police officers, nurses, when there is a sudden death, when someone is otherwise healthy. They're mandated to investigate that. So there is a statute that Dr. Atkinson told you a little bit about on cross-examination. So ask yourself, is it as unlikely? Is it bizarre? Because Anna Walshe worked out. Yes, she had been sick before. She had been with Alyssa Kirby in the days leading up to this, and Alyssa Kirby wound up having the flu. But that's not what really is at issue here. Sudden and unexpected death may occur because someone is ill. All we know is that it happens. And the fact that someone doesn't believe it could happen doesn't mean that it doesn't. Importantly, though, think about the shock of it happening. Think about the effect it would have on anyone. A lay person that has no idea it could happen. You're down celebrating with your wife and your friend, and then the tragedy happens. And you panic because you can't believe it. You don't understand it. And you don't think anybody's going to believe you. Context. I walked Trooper Keith through all of that information, something that he had not done yet. And so what did you hear? We went methodically. Sometimes, I'm sure for some of you, it was a little painful. It took a little while. But we went through hour by hour, day by day, that basically was the life and the experience that Anna Walshe and her husband, Brian Walshe, were going through in just the days leading up to January 1st of 2023. And what do you see? And you'll have that evidence. You won't have it compiled in the way that I presented it to you, because Trooper Keefe never saw fit to assemble it in a way where you could really see what was going on. But what do you see, and what did you learn from the evidence? Two people communicating by phone and by text, talking about sales of property, talking about investments, talking about the future, talking about reinvesting, talking about buying new property in DC, talking about all of that, and it's all in the text. Joking when Anna Walshe was ill and stayed home and told her husband that in the text. And then they joke about it. I'll get you a plunger. And she responds, it's right there on the text. Joking back and forth in the days leading up to New Year's Eve. I'll tell you what, I'll buy the plunger. You buy me a Porsche. And then you see him shopping for a Porsche for the woman that he loved. How does it go from, I'm going to find you the Porsche you want, that speaks once again to the financial issues that were non-existent? How does it go from that to someone who is purportedly premeditating and intending to kill his wife? And those texts lead right up until she arrives by plane in Cohasset to celebrate. So, context. Once again, divorce? About 11 minutes of talking about divorce and searching about divorce in 7 days of phone calls. And how did that divorce search come up? It came up in the context of protecting the family assets because they just sold the house in Revere that Jim Mutlow told you about. And they're trying to protect it. And the thought is to roll it over in a 1053C. And Mr. Mutlow explained that to you. Planning for the future. That is the relationship between Brian Walshe and Anna Walshe in the days leading up to January 1st. So now we have come to just the evidence that, once again, just explains their relationship. Not supposition. Not trying to make up what they said to each other. You have that in their text. You have that. Then we get to New Year's Eve. We get to a festive event, jovial, laughter, love, described in various terms, various ways. Not for 30 minutes, not for 1 hour, but for 5 or 6 hours. Laughter, talking about the future. Jim Mutlow described it for you. Brian Walshe cooking, standing across from the island, feeding both of them, talking, laughing. You see in the testimony that, yes, there was an affair. He didn't know it. He loved his wife. He treated his wife like the wife he loved, the mother of his children, until the sudden, unexpected event happened. Imagine you are so in love. You support your wife to get a job in DC. You're going to take care of the kids because, one, you love your children, but you want to take care of them. You want to share property and protect the assets, so everything goes into her name to protect it because he has this federal case. So let's protect our financials for the future. And then you hear the testimony of Alyssa Kirby. Yes, she was upset. There's no doubt Anna Walshe was upset. What exactly she was upset about? Maybe things weren't going really well in the affair she was having. Or maybe she was, in fact, stressed out. Who wouldn't be? They were living apart. She wasn't seeing her children. Now, maybe, it's up to her. Anna Walshe was a wonderful person and a wonderful mother. And that's why he loved her so much. But she had another life, and she went to Dublin, and that's another piece of evidence. They want to suggest to you he knows something about Dublin. Where is the evidence of that? None. And you hear Alyssa Kirby choked up with tears, sobbing on the stand, but nonetheless recalling a conversation she had on 12/29, 3 days before January 1st. What does Anna tell him? Well, I don't know if I love him as much as I used to. Those are her words. I'm paraphrasing, but that was the gist of it. But I want him to take responsibility. Why? Not so she could kick him out, not so she could leave him, so they could reunite as a family. That was what Anna Walshe was talking about. That's what she was thinking, even though she was stressed, even though she was upset. And things like that happen in families, but families make it through. And that's what she was expressing. That's what she was expressing to her best friend, Alyssa Kirby. Could I have exhibit 169, please? We are now at the end of the New Year's Eve party, and they sign the champagne bottle. And we were talking about the feelings and the emotions and the state of mind of Anna Walshe and Brian Walshe, and looking towards the future. And this is on January 1st. This is on the day that the tragedy happened. Can you find it? I'm sorry, 169. Oh, I apologize. My fault. I'm sorry. Exhibit 257. And that's the champagne box that was signed. And what are the words? What a year. And yet we are still here and together. Let's make 2023 the best one yet. We are the authors of our lives. Courage, love, perseverance, compassion. Those are the words of Anna Walshe talking to her husband. Look what she says. What a year, and yet we are still here. What does that tell you? Yes, they had been through a lot. She missed her children. What mother wouldn't? But they were working toward the future. And one final thing about the state of mind of Brian Walshe at this period of time. He made reservations for a New Year's Day dinner so he could be alone with his wife. And the evidence of that is in these records. And I'm not going to have it called up. I'll just tell you. Exhibit 79, page 186, record 682. That's the data. He's researching where to take her out. And you'll see a reference to Nightingale, a restaurant that I asked Trooper Keith about. A restaurant that's right on the line of Marblehead and Lynn. Exhibit 59, at 12:27, those records indicate that Mr. Walshe credit card used to reserve dinner for $573.76. So him and Anna could spend New Year's Day celebrating. And exhibit 170, a text from Nightshade Restaurant itself acknowledging the reservation. And those were the plans that he made. And the government will suggest that's some kind of evidence of premeditation. Well, it's not any evidence of anything but love. And I'll just tell you, when you look at that evidence, you'll see that that email exchange was deleted. It's right there in the evidence. And then you heard the federal probation officer saying he wouldn't be allowed to go there. He'd have to get permission. So yes, if Mr. Walshe lied to his probation officer For what reason? So he could take his wife out for a New Year's dinner, and that evidence, and the evidence that you saw in that champagne box, is what their life was right at the moment before the tragedy happened. That is the evidence. I'm sorry I talked for so long. I apologize. Mr. Walshe loved Anna Walshe, the mother of his 3 children. There's no evidence that he deliberately premeditated a murder. There's no evidence that he ever intended to kill Anna Walshe. None whatsoever. Mr. Walshe is not guilty. He's not guilty of murder. Thank you.
Jurors can't, why don't you take a moment to stand up? Everyone good? When you're ready, you may be seated. Now, here's the closing argument of the Commonwealth. ADA, yes. You may proceed.
Thank you, Your Honor. Anna Walshe is dead. Anna Walshe is dead because he murdered her, and he intended her death. Anna Walshe is not missing. She never walked out of her Cohasset home on January 1st of 2023 between 6 and 7 a.m. to take an Uber to Logan Airport. She wasn't going to DC for a work emergency. There was no emergency. She didn't say goodbye to her son. That's just a story that the defendant told people. But since January 1st, Anna Walshe has not been seen by her friends, her coworkers, or by the people who loved her. Anna didn't take an Uber. She didn't take a Lyft. She hasn't used her phone. Her phone's had no contact with the Verizon network since January 2nd, 2023, but it was in the vicinity of 516 Chief Justice Cushing Highway. She hasn't used her bank accounts, her passports, her credit cards, her email. She didn't vanish. The defendant was the only adult at 516 Chief Justice Cushing Highway after Jim Lulu left around 1:30 a.m. on New Year's Day. After he left, Anna was home alone with the defendant and their 3 sons, ages 2, 4, and 6. This defendant caused Anna's death, and the evidence does show you that. The evidence shows you that Anna didn't die of natural causes, but that Anna died a violent death in her Cohasset home on January 1st. You have the photos of those pieces of rug recovered from the dumpster at the defendant's mother's complex. The rug that had been in the living room. You have the photo of Anna in the living room on top of the rug. The photo shows that there are wood floors in that room. There's blood on that rug. The rug was recovered from the compactor outside of the defendant's mother's apartment and taken to the office of the chief medical examiner for examination. And Dr. Atkinson found a blood clot and a piece of Anna's Gucci necklace embedded in one of the cut up pieces of rug. So look at the piece of metal stamped Gucci. It didn't break on its own. The rest of the necklace is missing. This is the necklace that Will Fastow said that Anna often wore. Look at the slippers from the dumpster. The 2 pairs of adult slippers. The dark gray slippers have hair and blood clumped to the bottom. And the DNA testing tells you that the slippers had the DNA of Anna Walshe and the DNA of the defendant. Then there's the bathrobe. And there are 2 bloody white towels. A towel was tested and had Anna's DNA. Why did the defendant throw those items out? Because they had Anna's blood on them. And the evidence shows you this because the defendant was researching cleaning. How to clean blood from what floors? Does dishwasher clean blood? Is it possible to clean DNA off knife? The defendant still had a cut on his thumb on January 9th, 2023. And on January 1st, before he even went to Lowe's to buy any cutting instruments, an initial stop that he made when he left his house was to go to Walgreens to buy antibiotic ointment and Band-Aids. Then he went to Bin and Liquors, where the manager identified the defendant, and the defendant threw a bag into the dumpster. Store is closed. The parking lot is empty. He's not yet gone to Lowe's. On January 2nd of 2023, the defendant went to Home Goods because he had to buy a new rug for that living room to cover the hardwood floor. He did this days before the forensic scientists got to the house and knew that the rug had been changed. Anna Walshe dying a sudden death from natural causes defies common sense. She was in great shape. The defendant told police that Anna was a sturdy Serbian woman. Listen carefully to his recorded interviews, because those are his words after her death, after he killed her. Mark Salvaggi told you that Anna had the highest health rating from the life insurance company. Anna had to complete an interview, have blood drawn, provide her medical records, and the life insurance company and the underwriters gave her this health rating. Anna was an active person who took care of her health. Ashley Semino, her bar instructor, told you about this exercise class that she took the morning of December 31st, 2022. And Anna was the type of person, she said, who made others want to work harder in their exercise class. Will Fastow told you that Anna was very active and did yoga together. Sergeant Amy Waterman described Anna's home gym in BC. And Dr. Atkinson told you about the different ways a person can die, and that it's extremely rare for a 39-year-old in good health to suddenly die of unknown causes. But without a body, it's not possible for the medical examiner to tell you the exact cause of Anna Walsh's death. No autopsy can be done. The defendant deliberately got rid of Anna Walsh's body. The defendant did not want anyone to find Anna's body and to know how she died. So the defendant bought cutting tools at Lowe's and Home Depot, and he cut up Anna's body, the woman that he claimed to love, and he threw her into dumpsters. He was hiding her body. The defendant intended to kill Anna Walsh. He didn't just want her dead, he needed her dead. This was a marriage in crisis, and it was heading towards a breaking point. It began with the defendant's federal case. And through the defendant's interview and his federal probation officer, you learn that the defendant was on home confinement. He was going to have to pay over $400,000 in restitution, and the case had been pending since 2018. You also learned that the defendant had no assets. He told Jamulu that he only made $50,000 to $60,000 that year, but he had told the police that he had businesses that were not making any money at all. Peter Capozzoli told you that the defendant's mother had signed the lease for the Cohasset home, and it was his mother that was paying his rent. Meanwhile, Anna was beginning to thrive. The marriage was beginning to deteriorate. Anna had her dream job. She had risen to become an executive at Tishman Speyer, and she was making close to $300,000 a year. She earned a bonus. And Teresa Marchese said that Anna was a good employee. And the defendant knew this. He bragged of her bonus and salary. She bought a townhouse, and she furnished that townhouse for her family, and she set up bedrooms for each of her 3 boys. But the reality was, the family couldn't join her because the defendant needed the children with him. Being the primary caregiver allowed him to avoid prison. The separation of the defendant and Anna was taking a toll. Anna wanted the children with her, and Anna began a relationship with Will Fastow, which became more serious. The defendant and Anna were growing apart emotionally and physically. Anna struggled not having her children and not being able to be the mother that she wanted to be. This got worse when Anna took the trip to Serbia to take care of her sick mother. Anna and Will Fastow spent the Thanksgiving holiday first in Dublin before Anna went to Serbia. And Anna bought her plane ticket with the credit card that the defendant monitored. And the defendant told police that he monitored their joint Chase Freedom credit card statement. The MacBook history also shows the defendant looking at the Chase account. The defendant knew about Anna's travel because in a recorded interview, he told the police that she had a layover in Frankfurt, and that connection in Frankfurt is on the same credit card statement. And you can see that, it's right in front of you. The defendant was angry about Anna missing Thanksgiving, and he mentioned it repeatedly when he spoke to investigators.
I got angry about Thanksgiving, and then I realized it was just sad that we're not spending a lot of time together. And she was sad about it too, and it was exhausting for both of us. She was away from the boys, I was always there with the boys.
Anna returned from Serbia in December, but she only spent 1 day in Cohasset. And she was supposed to come home for Christmas morning. But she missed her early flight, and she couldn't get a flight, and then she had to drive up. The defendant told police there was an argument.
I did have an argument with her for the Thanksgiving and the Christmas Eve, so I wasn't going to make the same mistake 3 times.
So what did the defendant do on Christmas Day when his wife wasn't home? He looked up Will Festa on his cell phone, the man his wife had just spent the night with. The defendant was losing Anna. Anna was missing her children and wanted to keep them. Anna quickly returned to DC, and on December 27th, the defendant was looking up the best strategies to divorce for a man and the DC divorce laws. This was not to protect assets. That wasn't the search. The defendant told the police that everything was in Anna's name. The defendant had nothing without Anna and the kids. And on December 29th, Anna spoke with General Wu and told him that she was upset about the travel, upset being separated from the children, upset about the defendant's federal case. It was ongoing. It was getting to be too much. On December 29th, Anna went out with Alyssa Curry, and she broke down. This strong Serbian woman who was supposed to be having a fun night out with a girlfriend, going to dance karaoke, instead broke down. Anna told Alyssa that she had told the defendant that he needed to take responsibility for the federal case, go to prison. She wanted the children with her in DC, and she and the defendant had not been intimate in close to a year. In Anna's mind, the marriage was broken. Anna even questioned if she could just take the children because she had already established a separate household. She said that she was falling out of love with the defendant. And at home in Cohasset, what was the defendant doing? He was looking up the Mazda building and the FBI raid on the Crossing building. Looking up something that had happened in the spring of 2022 when Anna first started working for Tishman's Fire. Interestingly, this was when the defendant brought up something he brought up in his interviews when he lied about Anna having to leave early for a work emergency. He was planning the work emergency. The defendant was going to lose Anna, and when he lost Anna, he would probably lose his freedom. Anna would have a house in DC and a nice job, and he would likely go to jail. So the defendant pretended. He lulled Anna into thinking that everything was okay. He joked with her about a Porsche. He didn't want her to realize that he was aware of the relationship with Will or her ability to leave him. He wasn't going to let Anna know that she wasn't safe. On December 31st of 2022, the defendant claimed that he could not find his phone. Why is that important? The mislaid phone allowed the defendant to be unavailable for 2 days. The mislaid phone allowed him to carry out his plan uninterrupted. And the mislaid phone allowed him to show the police when he eventually reports Anna as a missing person and not have the police question why he didn't contact Anna earlier. The evidence shows that the defendant was methodical. Just look at how he shopped at Lowe's with a list. He planned it with precision. So Jem Lulu came over for dinner on New Year's Eve, and the defendant told Jem that his phone was lost and it was free. Anna was texting throughout the night, including with Will Fastack. This is now the third holiday where Anna was concentrating on the other man in her life. When Jem left, Anna was alone. She was with the defendant, the man she was cheating on, the man she was telling to take responsibility for his actions, and the man who had her children. The defendant murdered Anna that morning in their Cohasset home. And this is what the internet history shows. His internet history, written words. He was looking at best way to dispose of a body. Better to throw away crime scene clothes or wash them. Crime scene. Can you be charged with murder without a body? Anna was dead. The defendant killed her, and he began researching how to get her money, how to inherit, how to get away with the crime. And he might have gotten away with it, but he didn't know that his MacBook was syncing with his son's iPad, the same Apple ID. His demeanor changed during the interview on January 8th when the police mentioned the searches on the iPad. Not because the iPad involved his children. He had already involved the children in his lives, but because he knew he was caught. We know he had already involved the 6-year-old when he had the 6-year-old say that he saw his mother when she left the house on the morning of January 1st. The son could not have seen Anna leave the house. The defendant had already killed her. Listen to the recorded interviews. During the January 5th interview, the defendant spoke about what his son supposedly had seen. And the defendant involved the 4-year-old by saying that the 4-year-old hid the defendant's iPhone 13 mini. So, the defendant's phone made a reservation at Nightshade Noodle Bar for New Year's Day, after the defendant told Anna that they were going to have a special party. This is ironic because the defendant was very clear with police on January 7th that he and Anna had no plans for New Year's Day, and the defendant also knew that he would be violating the terms of his federal probation by going to a restaurant on New Year's Day. But let's look closely at Exhibit 170 about the Nightshade Noodle reservation, which was on the defendant's iPhone Mini 13, which the defense just said was deleted. And if you look on page 2, on the bottom of one of the bubbles, you will see that the message was deleted on January 1st at 7:59 and 5 seconds a.m. This happens to be one of the times that the iPhone Mini 13 was unlocked when it was supposed to be missing. The forensics show that the defendant's phone was unlocked 4 times and it was plugged in on January 1st. You heard testimony that the phone had a password of 197512. And in the January 4th recorded interview, you hear the oldest child needed help with his iPad password, which was 121212. The children didn't unlock the defendant's phone. The defendant blamed his misplaced phone on one of his children when he said that the children hid it. But it makes no sense that a 4-year-old somehow unlocked the defendant's phone and deleted that text reminder. Listen to the defendant's recorded interview. The deletion is made when the defendant is supposedly making French toast and playing with the kids. The defendant had access to his phone. Context. The defendant also had access to 2 other phones when his phone was supposedly lost. He had Anna's phone and he had the iPhone SE. And in the recorded interviews, the defendant told police that on New Year's Eve, Anna had an argument with a friend, and as a result, Anna put her phone upstairs in his bedroom.
You said she went and put her phone upstairs after that?
After that, she, let's say it's 10 or 15, then she, I remember her putting her phone upstairs because then she came back down without it.
Was, Thomas came down at one point and hung out with you?
Yes. Yeah, exactly.
Was this before, during, or after Thomas was participating as well?
Oh, yeah, Thomas went to bed at, he went to bed when he came over at like 9 or 10 or something. I think Anna took a bunch of photos. Jem and I don't have any because she didn't send them to us yet. But I think she sent one to Will Fasto. So that was when, that's when the photo was taken about. So just maybe 10 o'clock or something like that.
You know where upstairs she put her phone at that point?
Yeah, on her bedstand.
That's not what Jem said. Jem said that Anna was using her phone all night. Melissa Kirby texted with Anna. The defendant was telling investigators a story about Anna's phone. How else do we know that the defendant intended to kill Anna and had a plan for doing so? Look at his internet history. Look at what he did. The defendant set up an area in his basement where he surrounded it with plastic sheeting, wore a tie-back suit, and dismembered his wife, the love of his life. Hacksaw, the best tool for dismembering a body. Then, the defendant got rid of Anna's body. He got rid of her belongings. He got rid of her clothes and bag that he told police that she had, that she supposedly left on January 1st. He threw her in the garbage bags, tossed those garbage bags in different dumpsters. Disposing of a body in the trash. Chatham West apartment rental. The Claremont apartment rental. And police confirmed this with the location data from the SE phone and the iPhone 13 mini. The evidence shows that the defendant did this to hide the fact that he murdered Anna. He could not let Anna's body be found because Anna didn't die of natural causes. The defendant murdered Anna, and then he had to hide the evidence of his crime. In his mindset, look at his internet history. Want to get away with murder? Use a special detergent. Can you be charged with murder without a body? Best way to dispose of body parts after murder. When you deliberate, look through the binder of the MacBook internet history. There are no searches of natural causes of death, sudden death, heart attack, aneurysm, stroke, or how to help your children when someone dies unexpectedly or goes missing. The defendant was not sad. Look at his demeanor in the surveillance videos. He's cool and calculating. He's calm. He had a plan. On January 1st, he went to the Lowe's store an hour away, even though there were hardware stores approximately a mile from his house. And when he was in Lowe's on January 1st, he wore a mask and he wore gloves and he had a list of what he was shopping for. He was calm as he helped bag the purchases. A hacksaw, buckets. He used cash. Does this show confusion, panic, or fear? But he doesn't stop there. He went to CVS to buy hydrogen peroxide, and then he went to Stop and Shop to buy ammonia. No wonder the house was so clean. And on Monday, January 2nd, he went to Home Goods for rugs and handles. And then he went to Home Depot, where he had bought buckets with lids this time, baking soda, and a hatchet. And at some point that day, he got a call from his probation officer, and he lied, and he said that he was picking up his children. He was able to calmly speak with her. No panic. He had everything now that he needed to dismember the woman that he supposedly loved. And he started to take her body and to throw it into dumpsters, because he had to cover up the crime to get rid of the evidence of the murder. This was not a man in crisis. This was a man who on January 4th went to TJ Maxx to buy pants with the store exchange card. He was calm. But Alyssa Kirby texted him on January 4th asking about Anna, and so he called Tishman's Fire a few minutes later and started to pretend to look for her. He called Will Fastel, but he didn't leave a message. He called back later, and then he calmly left a voicemail. No panic. The defendant knew where Anna was. The defendant even texted Anna's sister in Canada and said that she was missing. He was methodical. Look at the text messages. And at 4:30 p.m. on January 4th, the defendant went to Lowe's to buy a trash can. Comfortable. Not combat. The police were coming to the house and to talk about Anna. And the defendant had the house ready. The police think his wife is in D.C. He had his phone records ready, and he sent text messages to Anna, even though he knew she would never see him. Despite everything that he had done, on January 2nd, the defendant wrote a text message to Anna. I still love you. Ha ha. Miss June. The defendant prevented anyone from ever finding Anna's body. There was no autopsy. Dr. Atkinson told you that the medical examiner can't do an autopsy without a body. And all that remains of Anna are a few hairs, some blood, and a few things that belong there. A part of a necklace she often wore, her hunter boots, a black jacket, a purse, her COVID card, and a few other items in the dumpster in his mother's apartment complex. The defendant searched his MacBook for a murder conviction without a body. Please do not allow the defendant's self-serving act of dismembering and disposing of Anna's body to let him get away with this murder. At the start of this trial, we asked you to use your common sense. When you do that, when you analyze the evidence as you deliberate and continue to use your common sense, you will see that the evidence shows there is only one verdict. Find the defendant is guilty of the premeditated first-degree murder of Anna Walshe. Thank you.
I will see counsel at the side of the bench.
sit on a throne of lies.
George, you're my guidepost. Do you need a break for the bathroom? Okay. All for one, one for all. Give you a break for the bathroom. Let us know when you're ready to come back out. I'll be at your disposal.
All rise, please. Jurors, follow me.
Seated. I will give you a quick break as well, but something's been on my mind that I want to discuss now that the closing arguments are over. And that is, I had asked in connection, this relates to the sentencing, at least for the other two counts. I'd asked the Commonwealth to provide victim impact statements for any immediate family members of Anna Walshe that wish to provide information, and I haven't received that yet. And there might be a good reason for that. I had told you that I was putting off the sentencing until we had a verdict on the charge of murder. But now that it's a Friday, and I don't want this to linger over until the next week, has the Commonwealth heard back from the Department of Children and Family Services?
Your Honor, we've been in touch with them. They are working on their impact statement. They were hoping to have the impact statement impounded. And I can, as soon as we're done here with the charge, I will speak to the attorney that I've been dealing with. They've been working very hard on this. They're certainly worried about their privacy interests of the children and the
I think there's a valid privacy interest of the children, and I'm highly likely to impound it, obviously, with the exception of counsel for both sides being able to see it so that they can make appropriate arguments as a result of the victim impact statement.
I think the department will be very happy to hear that. And they also, much of what they have is through a social worker privilege, so they're concerned about that as well. But as soon as we break, I will be happy to have that conversation.
Well, I'm happy to hear that there's forward progress, because I guess I assumed, because I hadn't heard anything, that you were still not getting the answers to the questions you were asking.
No, quite the opposite. They've been working very hard on this.
All right, I appreciate that.
Thank you.
Anything anyone needs before I step off the bench briefly? Thank you.
All rise.
Kind of a hint as to how some of that might happen. They let everybody back in for the latter part of the day, and there were a number of motions to go over. Primarily was the camera access issue. During the hearing, where the camera, and I'm not sure it was Court TV, it might have been Long Crime, I'm not sure, whomever had it, was parked in what would be the normal position for trial coverage. Here's the, I'm the camera guy. I'm the camera. Okay, and I'm looking out into the well of the court. I can see the defense table here. court personnel. You see my note today about the girl, young woman, who was sitting visually behind Brian Walshe. Everybody saw her. Who is she? What's she doing? I finally talked to her, find out what she's doing. She's a court officer, not a DA's or defense team personnel. She's like a bailiff in terms of the organizational structure. She's just there to note the proceedings. And I was not exactly excited because I said, everybody's been asking who you are because they can see when that side shot of Brian Walshe is on camera a lot, even when there's sidebar for minutes and minutes, she's sitting there. I don't think she liked that. I don't think she was looking for the limelight. Anyway, she was nice enough to say, "Get the hell out of here." I don't want to really talk about it. Fine. I'm just looking for some basic information here. I'm not looking to do an expose on whatever it is your job might officially be. Anyway, so that's the normal shot, right? And the jury box is right here. And that's the reason the camera is normally right here, because even though it happened when I was at Court TV, and, you get a glimpse of a juror by mistake. Sometimes they will put a piece of cardboard or some other obstruction on the right side so that if the camera pans just a little bit too far, that area is blocked, kind of like a seatbelt for the camera person, so that even if they go just a skosh too far, they've got a buffer zone, a buffer. That's a buffer zone that I can live with. So that's where this camera is, and that's where it's set up, okay? And here's what that looks like. Well, this is the tight shot. Let's let this roll, and we can talk about, there's the beast right there, and we can talk about what got people their panties in a bunch today, and I think arguably for the right reason. This guy was just weird today. He had a smirk at times, almost laughing, talking with his attorneys, and just total disrespect for what he's accused of doing and for the process. But he's gonna fry. Okay, so, and that's his attorney, one of his attorneys, of course. So they got him decked out in the tie that's got the Easter colors. But you can see he's smiling there, like this is all just at least I'm out of the clink for the day. I want to get the wide shot here so you can see what that normally looked like. There it is. Okay, just a basic wide shot. Okay, now then the jury box immediately to the right. Here's what happened. Somebody complained, and I'm going to bet I don't have. This is on information and belief. I'm not saying it under penalty of perjury. There's another one of his attorneys. Somebody complained that shot, especially the wider shot. Let me go back to that for you. Somehow showed potential things on the computer, and we know from the Michel Bryant's case in the death of Photostoulos, that became a contempt of court issue because the camera caught a document on a monitor. So that was referenced. But here's the one I think got everybody, and I don't even know that it was legit. But here's the complaint: that you could see the shackles on his feet. Obviously, the hand shackles are off, right? Somebody was complaining you could see the shackles on his feet. Now, I don't know, how you could. This is about as wide as the shot got. Let's see if there's any spot in which it gets even wider. Somebody, I think, said, well, when he was walking in, the shot was sort of wide, and you might have gotten that. Well, that'd be true no matter where the camera is. If he's walking in, like through the center of the court or from one of the rooms behind, and he walks across the well of the court, tougher to hide that. And of course, at this point, only because it's being publicized does anybody care. They're thinking, oh no, jury pool members are going to see this guy. He's in shackles, therefore he must be guilty. I mean, that's the crazy, thought process that gets you to the concern that anybody sees shackles on this guy. Oh, he's in custody? Shocking. Didn't know that. So somebody complained. Defense, maybe, don't know. They said, that's unfair. We have to do something about that. And so the court did address it, found that there was a violation of the order to not show the defendant shackled. And, somebody was going to get sanctioned. It was unclear who. The judge did talk to the camera person and remind them of the order. It's a decorum order, is what they call it. And then the judge said, okay, shut her down. Again, this is all from the original camera angle. Let's see if he's talking. Does he talk to us?
Minutes.
All right, and then we'll come back on the record and handle the remaining of this hearing. I appreciate the patience of parties as we move forward. We are trying to do the best.
Okay, so that's Judge, what's his last name again? I forget it right. Graff, Judge Graff. First of all, I don't like this. See this whole giant building that makes up the bench? First of all, it's very, I don't know, 60s, 70s, 80s, somewhere in there. It's just too much. It's just way too much. You need to create like your own little city up there. It's just too much. It really creates this illusion of I'm up here, I'm the Wizard of Oz. Everybody else is my subject. Okay, so then they go off, throw up a graphic, throw up some bars, and then we're back with the new location. This is now on, maybe the judge feels his right side is better and figured, hey, let's move the camera over there because my right side is better. I don't know any of that. I'm just kidding. Okay, so now here's the wide shot. See anything interesting in this wide shot? Anything you might have a problem with? Would this be at trial? Anything? Anything kind of stick out? Anything that stick out as maybe something you don't want to be showcasing? Oh yeah, the jury. I mean, this whole area here, this is the jury box. So instead of the camera being on this far right side of the screen here, shooting this way, it's now back over here, shooting this way, right into the jury. So clearly, this is not going to be the location at the time of trial, okay? Now, at the time of trial, he won't have any sort of shackles on. And the whole issue with the computer screens, they're gonna have to deal with that however they deal with it. You know, they make screensavers that limit the angle within which you can really see anything. Like you twist 15 degrees off and it looks black. There are ways to work around that. But this just seems so artificial. Just like, let's cave into whoever the whiny person is about this for now. But there's no way this becomes the shot at the time of trial. And it does sound like there hasn't been an official ruling yet, but it does sound like he is inclined to let cameras remain in the courtroom for this trial. So that to me was the most interesting thing that happened today. There's a number of pending motions. They want to recuse the entire prosecution team. That motion is out there. They did set a preliminary trial date in May, which the defense whined about because they said, we don't have, there are tons and tons of documents we don't have yet, right? So they're going to whine about it as it gets closer, but there's a lot of things happening. Like, is this prosecution team going to remain? Probably. I don't know if they've asked to recuse the judge or not, but there's a lot of shenanigans on the calendar before this even gets to any sort of evidentiary hearing. And the preliminary hearing will be fascinating. You know, nobody's going to tip their hand entirely, but with so much evidence out there, it's going to be interesting. We're going to hear a lot. And even if some of the evidence is suppressed for whatever reason, there is so much evidence. I mean, he is innocent until proven guilty. But to me, he's guilty. We have to just see it play out in the court, and hopefully it plays out in front of all of us. Hey, I wanted to throw this up there just because one of our favorites was asking for a little bit of support, and we obviously offer that at all times. Madera Beach Caregiver, we are thinking about you and hope others are as well. I hope you're well. Those around you are well. We're not sure what the challenges might be, but we're with you. So, okay, let me see what else we got here. Hold on. His attorney is the same attorney for Corey Richards. You know, good defense attorneys tend to collect those kinds of clients. And I haven't seen anything that bothers me about her offhand, but this is the first time we've seen him live in court. He will not be there next time. They picked another date, actually, on the 29th of this month. He's going to be listening from the comfort of his jail cell or some other room. And the other attorneys will be there to finish up what they began today and did not finish. So, yeah, what is her name again? This is not a case I'm knee deep in, kind of been into other stuff, so I can't remember her name. I wanted to look up Judge Graff because I don't know if you guys listened to any of it today. Let me see if I can get just a piece of him in here just for context.
Stand up.
Yes, please. I just so it's on the record, everybody saw the small edit I made to the verdict slip and everyone's fine with that, right? Everyone's not. So, thank you.
All rise to the court, please. Jurors entering. Court is back in session. You may be seated.
Welcome back, jurors. Jurors, I'm going to go through the remainder of the instructions, the final stage of this case before you will get the case to deliberate. The intent of the second part of the instructions is to give you some assistance in determining how you go about deciding whether the Commonwealth has proven each element of the indictment is true beyond a reasonable doubt. For the charge, you must decide whether the Commonwealth has proved beyond a reasonable doubt that the defendant is guilty of the charge. You may not find the defendant guilty on the charge just because you think the defendant did something else that was wrong or improper. Your decision as to the charge must be unanimous, meaning that all 12 deliberating jurors must agree. You will receive one verdict slip. When all 12 jurors agree on the verdict, the foreperson should check off that verdict and then sign and date the verdict slip in ink. In a little while, I'll go over that verdict slip a little bit more. For the charge, if you all agree that the Commonwealth has proved every element of murder beyond a reasonable doubt, then you should find that Mr. Walshe is guilty. On the other hand, if you all agree that the Commonwealth did not prove one or more of the elements of murder beyond a reasonable doubt, then your verdict must be not guilty. Let me talk about your role. Jurors, you have the most important role in this trial because you will decide who and what to believe and whether the Commonwealth has proved Mr. Walshe's guilt beyond a reasonable doubt. You must be completely fair and impartial and unbiased in your work as jurors. Do not let your emotions, any kind of prejudice, or your personal likes or dislikes influence you in any way. Consider the evidence calmly and carefully. Do not be influenced by the nature of the charge or the possible consequences of your verdict. And do not let your personal feelings about any person, criminal charge, or anything else influence your decision. All parties who come before the court stand as equals before the bar of justice. That a case is brought in the name of the Commonwealth does not entitle the prosecutor to any special consideration. Your verdict must be based on the law as I have given it to you, and on the evidence and the facts as you find, and nothing else. By contrast, my job as the judge is to impose sentence if the defendant is found guilty. Therefore, you are not to consider the sentencing consequences of your verdict at all. That's not your responsibility. So please put any issues about sentencing out of your mind. Let me next talk about evaluating the evidence. You must decide this case based only on the evidence that was presented at trial. You may not decide this case based on anything else. Do not consider anything you have read, heard, or seen outside of this courtroom. Those things are not evidence, and you may not base your verdict on guesswork, speculation, or suspicion. Let me talk to the important topic of the defendant not testifying. As you know, Mr. Walshe did not testify in this case. You may not hold that against him. Mr. Walshe has an absolute right not to testify because, as I've explained, he is presumed to be innocent and does not need to do anything to convince you that he is innocent. It does not matter why Mr. Walshe did not testify. It's not relevant to what you must decide, which is whether the Commonwealth has proved, based on the evidence presented at trial, that Mr. Walshe is guilty beyond a reasonable doubt. The fact that Mr. Walshe did not testify is not evidence. You may not consider it or even discuss it in deciding this case. Let me next talk about witness credibility. During this trial, you've heard from a variety of witnesses. With reference to any and all witnesses who have testified before you, you have wide latitude. As a jury, you can believe every single word that a witness says on the witness stand, or you can disbelieve every single word that a witness says on the witness stand. You may decide to accept parts of a witness's testimony and to reject other parts of his or her testimony. That's for you and you alone to decide. If there are any conflicts in the testimony, it is your function to resolve that conflict and to determine where the truth lies. In evaluating the credibility of witnesses, you may use various tools. You may consider the ability, the opportunity, and the reliability of the witness to see or hear something in the past, and then remember and later testify about it before you in this courtroom. You may consider the conduct of the witness, his or her manner of testifying before you, any inconsistency you may have found in the witness's testimony, any interest the witness may have in the outcome of the proceedings, any bias or prejudice or hostility the witness may have demonstrated while testifying before you, the level of accuracy of the witnesses testifying before you, and the reliability of the testimony as it developed before you. These are some of the tools that you have at your disposal to resolve disputed issues of fact in this case. There's one more point about witnesses that I'd like to specifically address, and that's expert witnesses. This term refers to witnesses who have specialized training or experience in a particular field, generally in cases that are tried in our courts, both civil and criminal. Witnesses may testify to facts that are within their own personal knowledge. That is, things they've personally seen or heard or felt. However, in a variety of cases, this one included, issues arise that are beyond the experience of laypersons. And in those types of cases, we allow a person with specialized training or experience, we call them expert witnesses, to testify not only to the facts, but to their opinions, the reasons for his or her opinions on issues that are within the witness's field of expertise and are relevant and material to the case. Because a particular witness has specialized training and experience in a field, doesn't put that witness on any higher level than any other witness. And you are to treat the expert witnesses just like you would treat any other witness. In other words, as with the other witnesses, it's completely up to you to decide whether you accept the testimony of the expert witnesses, including the opinions that those witnesses gave. It's also entirely up to you to decide whether you accept the facts relied on by the expert and to decide what conclusions, if any, you draw from the expert's testimony. You are free to reject the testimony and opinion of such witness in whole or in part if you determine that the witness's opinion is not based on sufficient education and experience, or that the testimony of the witness was motivated by some bias or interest in the case. You must also, as has been explained, keep firmly in mind, jurors, that you alone decide the facts. If you conclude that an expert witness's opinion, not based on the facts as you find those facts to be, then you may reject the testimony and opinion of the expert in whole or in part. You must remember, jurors, that expert witnesses don't decide cases, juries do. In the last analysis, an expert witness is just like any other witness, in a sense that you alone make the judgment about how much credibility and weight give the expert's testimony and what conclusions you draw from that testimony. Let me next talk about graphic photographs. The Commonwealth has introduced certain photographs showing items taken from various trash bags retrieved from 300 Forest Street, Peabody, during the investigation of this case. You will have those photographs with you during your deliberations, as all the evidence will be with you during the deliberations. Some of those photos, as you've seen, are not pleasant. Indeed, some may be described as graphic. I instruct you that your verdict must not in any way be influenced by the fact that these photographs may be unpleasant or graphic. The defendant is entitled to a verdict based solely on the evidence and not one based on pity or sympathy for the deceased, which might be occasioned by those photographs. Related to this, sometimes evidence is presented that produces in jurors an emotional response. For example, it is natural and understandable to feel sympathy and empathy when you hear or see testimony that suggests what might have occurred to Anna Walsh's body after her death. But as jurors who have taken an oath to follow the law, I instruct you that you must separate any emotional response or reaction on your part from the informational value and weight of the evidence. You must not be influenced in any way by the nature of some of the testimony and video evidence. You must find the facts in this case based only on the evidence. You can't find facts or base your decision, again, on sympathy, anger, passion, or prejudice, or pity for or against either side in this case. Rather, again, jurors, your verdict must be based solely on the evidence in this case and my instructions on the law. So what is evidence? I told you earlier that repeatedly that you must decide this case based only on the evidence presented at trial. The evidence consists of the testimony of the witnesses, as you recall it, the things that were marked as exhibits, and the stipulations, or I told you those agreements of the parties, which I read into evidence. You will have the exhibits with you in the jury room. Things that were marked for identification aren't exhibits, so don't be looking for those, because they're not exhibits, and you won't be able to consider them. Other things that are not evidence and you may not consider when deciding this case are as follows. The fact that the defendant had been indicted and charged with a crime, not evidence. Questions that the lawyer asked of a witness are not evidence. Only the answers given are evidence. For example, if a lawyer asked, wasn't it raining outside? And the witness answered no, or said, well, it was cloudy. The question is not evidence that it was raining. If a lawyer asked a question and I sustained an objection and therefore the witness didn't answer it, then neither the question nor the fact that the witness did not answer is evidence. If I struck or told you to disregard any part or all of an answer by a witness, then the part of the testimony that I struck, not evidence, you may not consider it. Anything that you may have seen or heard when the court wasn't in session isn't evidence. The opening statements and closing arguments of the lawyers are not evidence. And if your memory of the testimony differs from what the attorney said in their closing arguments, you should rely on your memory. Any notes that you've taken, they're not evidence, but you may use your notes to refresh your memory of the evidence. As you know, evidence can come in many forms. It can be testimony about what someone saw or heard or smelled or felt. It can be someone's opinion, and it can be an exhibit. Whether the evidence is direct or circumstantial, sometimes we call that indirect, The Commonwealth must prove the defendant's guilt beyond reasonable doubt from all of the evidence in the case. Some evidence proves a fact directly. For example, if a witness testifies that she saw and felt it raining outside before she came into the courthouse, then that's direct evidence it was raining. Some evidence proves a fact indirectly, circumstantially. For example, let's say a witness testifies that he saw someone come into the courthouse wearing a wet raincoat and shaking water off of an umbrella. That's indirect evidence that, if you believe it, might lead you to conclude that it was raining outside, even though the witness did not see, hear, or feel the rain. This kind of indirect evidence does not directly prove something is true, but it is evidence from which you could logically conclude that it is. We call this drawing an inference. We all draw inferences every day. We take some known information, we apply our intelligence and common sense, then we reach a conclusion. But inferences must be based on facts. They can't just be guesses that you make when you're not sure about something. Sometimes you can draw more than one inference. Also, you may draw an inference even if it is not necessary or inescapable, so long as it's reasonable and warranted by the evidence. You have to decide, jurors, which inferences are reasonable, and decide which seems more reasonable to you. It makes no difference whether evidence is direct or indirect. Commonwealth may be able to prove a criminal charge with direct evidence, indirect or circumstantial evidence, or a combination of both. Let me next talk about credibility. An important part of your job as jurors is to decide who and what to believe. You may believe everything a witness says, part of it or none of it. Sometimes people do not tell the truth. You must decide whether a witness was being truthful or deliberately lying. If you conclude that a witness lied to you about something, then of course, you should not believe that part of the testimony. Sometimes people make an honest mistake. You must also decide whether a witness testified accurately or whether the witness may have gotten something wrong without meaning to do so. A witness may recall seeing or hearing something but actually be mistaken. For example, the witness might not have paid close attention or might have misunderstood what was happening. Or a witness's memory of what happened could be incorrect. If you conclude that a witness tried to be truthful, but that some part of that person's testimony was inaccurate, then you should not consider the inaccurate portion. How do you decide whether you believe a particular statement by a particular witness? Well, ask yourself, did the testimony seem reasonable or probable? Did the witness have a good chance to observe what happened? How much attention did the witness pay? Did the witness's memory seem accurate? Was the witness's testimony consistent with other evidence, or instead contradicted by other evidence? How did the witness behave and answer questions while on the witness stand? Did the witness have any motive for testifying in a certain way, or have any other bias that may have influenced the witness's testimony? You should evaluate the testimony of a police officer or someone else who works for a law enforcement agency in the same way as you would evaluate anyone else's testimony. You must not automatically believe or automatically disbelieve a witness just because a person is a police officer. Moving next to the importance or significance of evidence. It's up to you, jurors, to decide how important each part of the evidence is, whether it's testimony by a witness or an exhibit, whether evidence is direct or indirect. You should give each piece of evidence whatever significance you think it deserves. You're not required to believe something simply because it appears in an exhibit. It's up to you to decide how important any exhibit is. You do not have to treat testimony by a witness as more or less significant than the exhibits. You may find that a witness's testimony is very important, or that an exhibit is more important. That is up to you. Next, I want to talk about the alleged victim's state of mind. You heard evidence of statements Anna Walshe allegedly made to William Fasto, Jem Bootlew, and Alyssa Kirby. Those statements are admissible for the limited purpose of establishing Anna Walsh's state of mind, as may be relevant to the defendant's motive or intent to kill. Those statements cannot be considered as proof of the criminal acts charged or as proof that the defendant had a bad character or a propensity to commit any criminal offense. Let me next talk about motive. First, motive is not an element of the offense of murder, and the Commonwealth is not required to prove or show motive. Evidence of motive can be relevant to the issue of intent. Second, an absence of evidence of motive may tend to raise a reasonable doubt. Third, even a total lack of evidence of motive would not necessarily raise a reasonable doubt as to the guilt of a defendant, so long as there is other evidence produced that is sufficient to prove the guilt beyond a reasonable doubt. Let me now move to the area of something called consciousness of guilt. Spoke earlier about inferences and the drawing of inferences from indirect or circumstantial evidence. At this point, I want to talk about a particular type of inference based on a legal doctrine called consciousness of guilt. In the course of the trial, there was some evidence suggesting that the defendant may have intentionally made certain false statements before his arrest and that he may have taken steps to conceal Anna Walsh's body after her death. I want to stress to you that I'm not suggesting that he did so, or that you should find that he did so, but only pointing out that there was evidence to that effect. It's up to you to decide what evidence to accept or reject, and what facts to find from the evidence. I point to that evidence to illustrate the legal point involved. If you find from the evidence that the Commonwealth has proved that the defendant provided false information to the police and or took steps to conceal the body of Anna Walshe after her death, then you are permitted to consider whether such actions indicate feelings of guilt by the defendant, and whether in turn such feelings of guilt might tend to show actual guilt on the charge. You are not required to draw such inferences, and you should exercise great caution and do not do so unless they appear to be reasonable in light of all the circumstances in this case. You should always remember that there may be numerous reasons why an innocent person might do such things. Such conduct does not necessarily reflect feelings of guilt. Please also bear in mind that a person having feelings of guilt is not necessarily guilty in fact, or such feelings are sometimes found in innocent people. If you decide that such inferences are reasonable, it's up to you to say how much importance to give them. But remember that such evidence is never enough by itself to convict a person of a crime. You may not find a defendant guilty based upon such evidence alone, but you may consider it along with all of the other evidence in this case. Next, I want to speak to impeachment by the defendant's prior or subsequent bad acts. The only charge the defendant is now facing is the charge of murder. You have heard mention of other acts allegedly done by the defendant, namely, that he was charged in 2018 and sentenced in 2024 in a federal case involving art fraud, and or that he lied to the police, and or that he disposed of the body of Anna Walshe, and or that he lied to his federal probation officer. You may not take the defendant's prior or subsequent acts as a substitute for proof that he committed the crime charged, nor may you consider them as proof the defendant has a criminal personality or bad character. You may consider this evidence solely on the limited purpose of the motive, state of mind, intent, plan, or absence of mistake or accident on the part of the defendant. You may not consider this evidence for any other purpose. Specifically, you may not use it to conclude that if the defendant committed these other bad acts, that he must have also committed murder. It would be extremely unfair to consider this evidence for those purposes. Moving next to your notes. Many of you have taken notes during this trial. Your notes may help you remember the evidence, especially the testimony, but of course they're not an actual transcript or official recording of what was said. So use your notes only to help you remember what you saw and heard in the trial. Whether you took notes or you did not, you must rely on your own memory of what the witnesses told you. After the trial is over and you've returned your unanimous verdict, the court officer will collect your notes and I will order that they be destroyed. During the trial, the lawyers occasionally, as was appropriate, objected to questions posed by the witnesses. They may have asked to strike something or, in essence, erase something you saw or heard. When a lawyer believes that something would violate those rules of evidence we've talked about from the beginning, that's the only way they have to let me know. And so don't hold it any against the lawyers that they made such objections. It's part of their job. I want to next turn to fairness. Each of you has taken an oath and promised to be fair, and I'm sure you want to be fair, but that's not always easy. Part of being fair is being willing to examine your decision-making process to be sure that you base your decisions as jurors only on the evidence and the law. One difficulty comes from our own built-in expectations and assumptions, and they exist even if we're not aware of them. We all have them simply because we're human beings. They affect our actions and decisions without us even realizing it. As a judge, I have the same problem as everyone else. So let me share a few strategies that I found to be useful. These strategies will help you make sure that you decide this case based, again, only on a careful examination of the evidence and on the legal rules that I'm teaching to you. First, slow down. Do not rush to a decision. Take time to consider all of the evidence. Quick decisions are more likely to reflect stereotypes or assumptions about people that we might not even be aware of. Second, as you start to draw conclusions, consider not only the evidence that supports your conclusions, but also think carefully about any evidence that undermines or weakens those conclusions. Third, as you think about the people involved in this case, ask yourself, would my decision be different if the people were different? For example, what if the people involved were from different social or economic groups, or different ages, genders, gender identities, or sexual orientations, or came from a different racial or ethnic background? Fourth, listen to each other. Other jurors may have different points of view. If so, they may help you make sure you're focusing on the facts. Of course, other jurors could be influenced by their own unstated assumptions. So don't hesitate to share your views. You should participate actively, particularly if you think other jurors are overlooking or undervaluing evidence that you think is important. When you explain your thoughts to your fellow jurors, you help everyone focus on the evidence. If you do these things, then you'll play your part in reaching a decision that's as fair as is humanly possible. And that's your obligation as jurors. Now I'm going to move to giving you some instructions about how to conduct your deliberations. Privacy. The first point you need to know is that you must keep your deliberations secret. You should not tell anyone outside of the courtroom, not even me, anything about your deliberations. For example, please do not tell me or anyone else the results of any votes that you may have taken before you all agree on a unanimous verdict. You must not tell anyone about how your discussions are going or what other jurors are saying. If you need to communicate with me before you reach a unanimous verdict, you should send me a written note and a form that you all agree on. The court officers have it. It must be signed by your foreperson, and I will discuss your note with the lawyers, and then I will either send you a response in writing, more likely, or bring you into the courtroom, less likely, and respond to you in person. If you do send me a note, do not mention any votes that you have taken or anything else about your deliberations. Do not talk about this case unless all of you are present and no one else is in the room. If one of you needs to leave, even for a moment, the rest of you should stop deliberating until that juror returns. That includes the bathroom breaks, because I know that was right inside your spot. If we break for the day without you reaching a unanimous verdict, you must not communicate with the other jurors about this case until the next day, only after we gather in the court and I ask you to resume your deliberations. As you work to decide this case and until I accept your verdict, you must not communicate with anyone else about the case except each other. And you must not do any kind of research about this case. You may not do so in any way, including with electronic devices, a cell phone or a tablet. This also will apply to the alternate jurors. We talked about those alternate jurors. The law permits only 12 jurors to participate in deciding a criminal case. There are 16 of you here. So in a few moments, our clerk is going to randomly select 4 of you to be what we call alternate jurors. The other 12 of you will work together to decide this case. We chose 16 of you originally in the case, just in case one or more of you got sick or needed or had some other unexpected emergency. If you are chosen as an alternate, your continuing service is still very important, and you must comply with all of the rules that I placed on you. The alternate jurors will stay in another room, and you can't have your own private deliberation. You can't discuss the case with each other or with anyone else for obvious reasons. If we lose a deliberating juror in the group of 12 because of some personal emergency or sickness, then I will send one of the alternates into the jury room. If this happens, the deliberating jury will have to restart its discussions from the beginning. One of you is going to serve as the foreperson of this jury, and we will discuss who that foreperson is going to be in a moment. Foreperson will make sure that each of you has the chance to speak and that the other jurors listen to you respectfully. But the foreperson's opinion about the case is no more important than the opinion of all of the other jurors. Once you agree on a verdict, the foreperson will fill out the verdict slip and will report your verdict in court. I want to next talk about making decisions as a group. When you work together as a jury, you will be making decisions as a group. This kind of decision-making is very valuable. Why do I say that? When a jury hears and sees evidence, each juror acts as a safeguard for the others. For example, someone else may recall evidence that you missed, and each of you will have insights that will help the other jurors make sense of the evidence and reach a verdict. No member of the jury is more or less qualified than any other juror to decide who and what to believe. You've all heard the same evidence, listened to the same witnesses, and looked at the same exhibits. And you have all taken the same oath, promising that you will, well and truly, try the issues between the Commonwealth and the defendant according to the evidence and the law. So, you are all equally qualified to reach a verdict. I have a few more suggestions that might help you work better together. First, you should discuss and analyze the evidence before you take any votes about a verdict. Voting first could keep you from discussing the issues and hearing other people's perspectives before making up your own mind. Second, I encourage you to discuss not only the evidence you think supports your view of the case, but also what evidence you think might lead you to make a different decision. Third, as jurors, and as the other jurors talk about the evidence that they found important, listen. In order for this process to work fairly, each of you should hear every other juror's insights and ideas. Please be open to them, since they might influence your own thinking. Fourth, don't be shy. As in any group, some of you may feel more comfortable than others sharing your thoughts, but you must have the benefit of everyone's input to help you reach a just verdict. For example, you may be the only one that remembers a particular piece of evidence or has a particular point of view. The more points of view that you all hear, the more effective your deliberations will be. Fifth, don't be afraid to change your mind if the discussion persuades you that you should. But you should not accept a decision just because other jurors think it's the right one. In the end, you should vote based on your own assessment of the evidence, regardless of how other jurors have voted. Ultimately, jurors, each of you must decide this case for yourselves. One last pause to consult with the attorneys. So I talked to you about a four-person, and I talked to you about what we call reducing the jury. That is, reducing you down from 16 to 12. I'm appointing juror number 138 in seat number 6 as the four-person of this jury. Our clerk is now going to randomly select 4 of you from among all the jurors except the four-person to serve as alternate jurors. So what's physically happening is juror number in seat number 6, juror number 138's number is coming out of the, thank you, Madam Clerk.
Your Honor, numbers 1 through 16, case section number 6 of this. Your Honor, our first alternate is the juror in seat number 12.
Grab me, then no book in the swallow, man.
Our next juror, our alternate is the juror in seat number 5. Juror in seat 15. And our last alternate, Your Honor, is juror in seat number 11.
One last substantive thing that I want to go over with you jurors before I really get into the finally, the concluding remarks. And that, as I said to you earlier in this second part of the charge, that I would go over the verdict slip. There is a verdict slip, and I know that you can't, unless you have stellar vision, you can't see it from where you are, but you can get the layout of it. I'll read it to you. The verdict slip reads, count 001, on or about January 1st, 2023. And it puts the charge, murder in the first degree with deliberate premeditation. That is the charge. We, the jury, find the defendant, and there are three options. Not guilty, guilty as charged, murder in the first degree, guilty of murder in the second degree. And there's a place to sign it and date it. And again, the foreperson in pen, not pencil. This time, Madam Clerk, I'm going to ask you to swear in the court officers.
Please do solemnly swear or affirm that you will take charge of this jury, keep them in some secluded places where they can be. You should not speak to them or suffer anyone else to speak to them except by order, or would ask that they be said.
I will.
So now the deliberating jurors, the 12 of you, are going to go and start your private discussions. Have confidence in what you are about to do. By serving on this jury, you carry out a long and proud tradition of citizens of the Commonwealth of Massachusetts serving on jury trials and deciding criminal cases. If you are honest, thoughtful, and fair, you will be able to reach a fair and just verdict, dictated by your logic, without bias, without prejudice or sympathy, and not prompted by any facts except those that you've heard here in the courtroom during this trial. All we expect from you jurors is that you decide this case with integrity and principle. And with that, I'll ask you and let you go back to the deliberation room to begin your work. Thank you very much.
Court, all rise, please. Here's take your notebooks with you and follow me.
So I will, as I said to you at the side of the bench, there's some small edits necessary to impact. You may be seated. There's some small edits that I need to make to the instruction, and I'll make those now, take the draft off, make sure the numbers are all right for the index that goes down with them. Anything else that the parties need to bring to my attention before I do that?
We received materials to secure those items, and we're going to work on
Okay,
that.
do that. Are they, or you're going to?
We're going to secure them. I haven't had the opportunity yet.
All right, let Madam Clerk know when that's done, because I do want to take a look at the report as well, for us, take a look at those, make sure that they're comfortable with what's going on in the jury room.
And we thought we'd cut up pieces of parchment paper for the jurors if they need to examine anything that they can place on their table.
Do you have a roll, they can do it themselves?
We have a roll. We can give them scissors if you want.
Well,
I think that's why I put that out there.
all right.
Thank you.
I think you're pretty familiar that I have a 10-minute rule, which means at all times, Madam Clerk should be, the whole committee should be able to return to the court within 10 minutes, all right? I won't take it further between the hours of 1 and 2 on any day, with the opportunity to attend to your other work.
Thank you, Ron.
All rise.
You are unmuted. Hey, everybody. Interesting day, right? Nice, pithy closing arguments by each side, I think, although Larry Tipton's amazing. This guy, he does all of the things that you want to see in an attorney, especially when it comes to the closing. He barely uses his notes. He's talking to the jury. He's talking with the jury. He's animated. He punctuates what he needs to make a point on it. It's a pleasure to watch the guy. He has a little of the Southern lawyer kind of feel. He doesn't have the accent, but just kind of a folksy. And when I say that, I mean that in a good way. Maybe I say that because people have suggested I have kind of a folksy way about me when I'm in the courtroom, and I think it just means you're connecting with people. And he does. He does. And he had a lot to work with. And we're going to get into some of that. I don't want to spend a lot of time on this. We're going to let you deliberate, let the jury deliberate. My clock's probably just a touch later because I gave them time to get the hell out of the room. I didn't start it at the moment that the judge said, okay, start your deliberating. Anyway, oh, yeah, of course, you know why I'm wearing this shirt. No, not because I have bad taste. It is Justice Watch beginning, and so that's the only time this shirt makes an appearance. So, may it lead to the right justice, whatever that may be in the minds of this jury. One thing I wanted to talk about, because there's been a lot of back and forth about it, and we learned today more about the lesser charges. We were talking about it yesterday, and the fact that there had not been a request for the second-degree murder charge in open court. We talked about how the way the statute's written, there needs to be a request. It doesn't have to be an open court, but it has to be a request. So I figured, rather than, just kind of talk about it, let's look at it, shall we? Let's take a look at the law. This is the way it plays out. It is not done automatically, all right? I'll tip that off to you, which is what we talked about yesterday. It is not done automatically. Let me see if I can make this larger, just a touch larger, without losing some of the verbiage. Okay, the offense of, we know in this case, first-degree murder, includes the lesser offense of second-degree murder. As a matter of law, now that's where people, I think, get confused. The complaint that is before you, which charges the defendant with first-degree murder, also charges him with the lesser included offense. That makes it sound like, as a matter of law, it comes in. It doesn't. This is just the jury's instruction, and we'll get to what the law really is, because I think that's the important part. Commonwealth may prove the lesser included charge of second-degree murder, even if it fails to prove the greater charge of first-degree murder. You may find the defendant guilty of second-degree murder only if you are not convinced beyond a reasonable doubt that the defendant is guilty of first-degree murder, and you are convinced beyond a reasonable doubt the defendant is guilty of second-degree murder. Okay, so you got to, I don't want to say dumb it down, but basically you want to make sure the jury understands the relevance of the two charges and how they interact. The judge also instructs the jury, if you are to find guilt, it's at the highest possible charge. Okay, so how do we learn exactly what that all means and how it plays out? Well, just look into the notes. Number 2, when the charge is required or permitted, the judge must, on request, charge the jury concerning a lesser included offense if the evidence proves a rational basis for acquitting the defendant of the greater crime charged and convicting of the lesser included offense. So you got to have it requested. Now, it could be as simple as, remember, as this trial continued, we noticed that far more events were being held sidebar and far less in open court. So I have a feeling at one of those many sidebars, especially toward the end and during jury instruction conference yesterday, I would see them go to the sidebar, and it could have been as simple as Judge Frenier saying, you guys want the lesser includeds on this? And Tipton saying yes or no. Commonwealth saying yes or no. And that was the end of the discussion, and that was the request. That's how simple it could happen. It doesn't have to be a big proclamation, but it can't be done sua sponte without meaning only of the court's insistence there on the court's own order, unless there's some major reason to do that. And then the other parties, they can object to it if they want. Here's how it's been reviewed in some cases. Even if supported by the evidence, such an instruction is not required if neither party requests it. The parties are entitled to know at the charge conference whether the judge will give such an instruction. So I'm assuming that happened yesterday during some of the sidebar off-the-record conversations. It is error to charge over defense objection on a lesser included offense not supported by the evidence. So the one thing that I wondered about as I was boning up on this is why didn't the defense, or why maybe it was an issue, we just won't know, but why didn't voluntary manslaughter become, an option? Voluntary manslaughter is basically the heat of passion analysis, which is what I think. I think if it did happen, if it wasn't sudden, unexpected, unexplained death, I think it was a heat of passion scenario. I don't think there was any level of premeditation. So that wasn't requested, it wasn't included, and perhaps the defense felt like, why give the jury that many options to find my guy guilty? At this point, I think Tipton did a great job of pointing out the weaknesses in the Commonwealth case. And I wouldn't mind going through a couple of those with you. If you got a minute? You got a minute? Sure. Let's see. Again, I forgot to start the clock on Mr. Tipton's argument. I think it was 45-ish. Somebody else, I'm sure, had a clock on it. Let me know. It's an interesting observation. Judge is a ringer for Jackie Kennedy Onassis. It does look like the way she styles her hair has that big wave in it. There's no doubt about that. And I really like her a lot. I like the split instruction. I like that. We know that a lot of things that happen in court weigh on your attention span, especially these days. We're also scrolling and zooming and looking at 5 things at once. So when somebody's just trying to talk to you about some very important stuff, you might tend to zone out and drift off. So she splits it up, and I think that's great. So, oh yes, that is true. There it is. Brooklyn knows. This is I love this shirt. This is I have a lot of Untuck It shirts. I put that in the category of stuff I wish I had thought of, which is to create, it started just with shirts. Now they do everything. I mean, Untuck It makes perfect sense talking about a shirt. It's a shirt to be worn untucked, right? Because most dress shirts, if you wear it untucked, they're too long. Now they do everything. I don't know what an Untucked pair of socks means, but they do everything because they've been so successful. It's a guy, I think he's out in, I believe he's in California. I believe he's in the hometown of San Francisco where they opened up one of their first stores. But just brilliant. And I love them. And now the prices started to go up on them, because I'm a cheap bastard. So I never buy them unless they are on sale or there's a special discount code or something like that. This shirt, actually, I think was worn by the founder in one of his commercials for the company. So I don't know if he was trying to just sell a bunch of them, or he couldn't sell them to anybody. He was stuck wearing them himself. Okay, 12:22. That's Missy's official start. That would mean my clock is about 2 minutes, about 1 minute shy. So if I knew how to adjust this, I would. But this is an inexact science because we don't know, when it comes to lunch, if they're going to deliberate through lunch. I mean, clearly they're about half an hour from their normal, quote, lunchtime. They may go in, sit around for a minute. They know who the foreperson is. Remember, it's pointed out by the judge. And that was one thing, hold on a second here, that I wish I were in the courtroom to clean up my notes on, because I've got all my jurors here, but I don't remember how they ordered them. Is it 1 through 16, going 1 to 8 across the top, 9 to 16 on the bottom? I'm working on finding out. We have people that are in the courtroom, because today is like a parachute day, I call it. That's when those who have been maybe sort of interested in the case, maybe kind of following it, they jump in. Today is like the Super Bowl. I've been to a few Super Bowls, and every one, you look around, there are people there that have no clue who the players are, no idea who the teams are, and could care less. But they're there because it's a scene, right? It's a thing. That's happened the same thing in trials. We got people that parachute in at the end of the trial. Quite often it happens with mainstream media. It may also happen with streaming as well. Because when I'm there, it was me and the local press, and that was it. There might have been one other streaming channel one day that I was there, of the 4 days I was there. Anyway, so today it's, hey, let's go because it's the Super Bowl. So we're working on getting some details so we can go through who the people are that are now actually doing them deliberating. We know that number 6 is the foreperson, and so depending on how you count up my seating chart here, if you're going for the back row, it's either a white male in his about 50-ish, or if it's the front row, it is a black female, about 40-ish. So that means I have no idea until we find out how they were ordered. And then, of course, we can also then look at number 12, number 5, number 15, number 11. Those are the alts that are now in play. Okay, so we will find that out. Some people think this thing's going to be over by 1 o'clock, 2 o'clock. I don't know. I do like how Judge Frenier tells this jury, among other things, do not rush. Take your time. You've been here 2 weeks. Also, something that Judge Bev mentioned in the Karen Reed case, I know Linda and I talked about it. Linda didn't like that both in that case and here with Judge Frenier, she's discouraged the jury from straw poll, basically. Don't do any early voting. Try to see where everybody is. Talk about the case first. Just do it instead of rushing to any sort of conclusion. And so it may be part of a standard, Massachusetts court procedure. They give some of these instructions may have seemed kind of like informal, and I'm sure that each judge gets to do what they want to kind of mix their own personality in, but some of them are kind of structured. And it seems like to have two judges that are clearly on opposite ends of the universe in terms of fairness and bias, to both give that similar instruction, I'm guessing it's probably part of the mix for the Massachusetts Superior Courts. Okay, so where's my notes as we began the fine closings to see what Mr. Tipton focused on? Obviously, he's pointing out everything the Commonwealth did not prove, in his opinion, in his argument. No motive, no proof that Brian Walshe knew about the affair. He talked about really 4 different motives: the affair, money, 3 different motives: the affair, money, and then one I hadn't really thought about or didn't think was fleshed out, and that was that he was afraid to go to prison. Well, I'm not sure how that would be a motive for him to kill his wife, but okay. So anyway, he again didn't flesh that out very much, but neither did anybody else in court. The focus was on the motive for money and the motive of an affair. So do you think that he knew anything about the affair? Do you think that one nugget that the prosecution played on, which was the possibility he was getting iMessages from an iMessenger or from Facebook or some source that was not directed to him, but it was Anna to boyfriend Billy, did he actually get that? I'm unclear as to whether the evidence was that strong that he got it. There was just seemed to be a vague indication that he might have, that somehow there were messages that he may have gotten. So I don't know. I don't know if that's strong enough to now infer he knew, because that's where you're going to get to motive, and obviously then you get to intent. The money thing, much more interesting. And we know there was a lot of conversation about the divorce, and was that just to do some reorganizing the family assets? Well, if you look deeply into the family assets, as was pointed out by the Commonwealth, they were already in her name, pretty much in Anna's name. So what was the point? What are you protecting, if anything? So I don't know. It definitely muddied up that discussion by the defense that you've got a reason to square away the family's finances. Well, if they're pretty much all in her name, what's left to square away? So clearly that's a critical issue. I think from a human nature perspective, the affair is the best motive. That's going to get you where you want to go. If you're the prosecution, that's what I believe. And I don't know. I don't see enough motive there, evidence of motive / to get me to intent, than to get me to murder. I just don't. And obviously this jury, that's to me, that's what they've got to tackle. There's no doubt by that. Okay, I was trying to take a moment here to look at some of the stuff flying by, because I have a bad habit of not. There we go. Thank you, Donnie Not Wahlberg, Justice or TV membership. Always appreciate that. If you're a sub and you haven't been unsubbed, then maybe you'll get yourself a membership. And we've got we started doing more member stuff, which I felt was so important. We want to not just give you a reason to be a member, but reward you for making the commitment, which we appreciate. So some of the stuff we've done though at member level is turned over to public. In fact, over the weekend, you'll hear we had a conversation with Mizzy and with Barb, the second cousin of Sandra Birchmore. That's going to pop out over the weekend, and something else we did that I can't remember, but we will turn those from member into public. The beauty of the member part is, you see what we're doing earlier, but you also get to take part because we are doing those live. So, quiet, calm, rational judge. I can't take it. It is shocking. It does blow your mind when you see it done the right way. And not only is she human and admits to having certain flaws or weaknesses. She talked about it yesterday when crafting instructions, how she occasionally, feels like I missed something. I'm not quite there. Since 2017, when she became a judge, she's been trying every time to become, perfect or as close as you can get to it. And she admits, I'm not there. I'm not there. But I think she's got a future, which is unfortunate because you need judges like this on the bench. You need judges that get it and seem to be, by all accounts, very fair. But thing is, as in most industries, the better people rise to the top. And in this case, better means going onward to the appellate court. And again, need good justices in the appellate court as well. And hopefully the SJC, by the way, coming to the decision on the Kelsey Fitzsimmons case. I just looked before I popped on with you. Still nothing, at least on the docket. They've come to a decision in her case. As people know, she is still in jail for not being able to do this gram alcohol blood alcohol breathalyzer test, which is ridiculous. Anyway, if you want to see any of our links, thank you, Sheila. I appreciate you putting that up there. Okay, so more stuff from Mr. Tipton. He's making a point of when talking about this sudden, unexpected death, that you can't discount it just because you feel sorry for Anna Walshe, whatever happened to her. And we don't know what happened. Or you can't do it because you feel angry about some of the things you may have seen in this case. Or you can't do it because you're upset and it makes you just passionate about justice for Anna Walshe. You've got to stick with the evidence that you're looking at. And he said, and repeated many times, there is no evidence of intent. And I think that's the weakest point for the prosecution. I've seen no evidence of intent. And I thought it was interesting. I think it was in the Commonwealth's closing argument, but it might have been in Mr. Tipton's as well. They're talking about, maybe it was even in the judge's directions, seeing images. And I think maybe it was the judge saying some of these images you might even consider graphic. And I'm thinking, of course, I'm jaded by having seen who knows how many trials in person and covering them. These images were far from graphic. They're nasty, but the graphic part is right here in your head because you're seeing these tools and you're seeing blood, some substance like blood on a rug, and you're putting it all together in your head. That's the imagery that is graphic and disturbing. These images, I've had worse bloody noses. I mean, I'm not trying to minimize what may have happened here, but that's a fact. It was a clean crime scene if you consider it was dismemberment of a human body. So I don't think the imagery in and of itself is that big a deal, but what your brain does with it, that can lead to some pretty horrific images. Let's see, blood detection. And that referencing that the blood that was found, no evidence of violence, says Tipton. Now there's obviously the implication, because what are you going to do with a hatchet and a hammer and a saw and a knife if it is not to do something violent on somebody? If, again, as it was with the handle for sure on the hacksaw, there was blood detected there. The knife, I'm not worried about the knife too much. Hopefully the jury won't focus on that because there really wasn't, even from the prosecution standpoint, they couldn't say there was blood on the knife. They couldn't say, find the knife above the fridge. You have small kids, maybe that's where you got to hide your knives. And I'm very curious to see, the court had said, find a way to mount that knife on a board or something so that the jury can take it in as part of the evidence, as it is, and consider it. And, obviously, my brain starts going wacky. Like I can just see them handing, the knife from one juror to the next. Oh God, each person getting cut up by this knife. Yeah, you don't want that. So we'll see if I could tell the prosecution had not considered the mounting of the weapon, the alleged weapon. And so it was one of those, I think Greg Conner said, yeah, we're working on that, Your Honor. You were not working on that. No, not until she brought it up, because it's not something that you would want to have to do at last minute, because, just mechanically, when you get some foam board or something and some zip ties maybe to lock it in place. It sounds like a DIY project for me, but it's not something you're thinking about. You either got it lined up or you're scrambling. So, and I think they were scrambling. Let me think. On occasion, and we've talked about the blood spatter. There was no blood spatter in this case, which we find in so many, real bloody crime scenes. Spatter is routine. And I've talked about poor Domino. There's Domino. What a surprise. He's sacked out. Can you see him there? There we go. How's it going? Yeah, right. He is, once again, every winter, he gets this dryness in the tips of his ears, and it cracks, and he violent. Talk about violence. He shakes his head. It's a nose to tail wag, and it moves through his whole body. And if you're near that tail, it's like getting whipped. But his ears take a beating, and in this dry winter air, because we're looking at we get 15% humidity, sometimes less in the winter. Those ears get cracked, they start to bleed, and he shakes his head. And when we first noticed this, it was a year and a half ago, he's 3 now, so he survived the first couple of winters. But the first time it happened, what the hell's going on? And he whipped his head back and forth, and it was blood spatter, like the basement. Looked like a crime scene. Maybe I even Googled how to get blood out of concrete. I don't remember, but that's blood spatter, and it was not there in this crime scene, if that's what it was. Let's see. Quick claim. I think an underlying motive is Anna gave Brian the idea to sell the fake Warhol paintings. So that's boy, you're bringing her into that mix. That's interesting. Anna gave Brian the idea to sell them. I don't know. I'm not going to put that on her. I think the mastermind on that was Brian. That seems, and we've looked at the paintings, which boggle my mind that anybody would pay that much for real or fake. But anyway, it's an interesting spin. Okay, back to some of the notes I have here. Again, Tipton pointing out that, there's no evidence of premeditation. He poo-poos the porn. Remember the porn reference, or do I have to say corn? I don't know. These YouTube rules are annoying. About a cheating wife, and saying that, they're just throwing this. This is, he didn't say it, but this is like the, let's throw everything at the wall and see what sticks. That's where we are. And he said, why would you put any weight at all in those searches, movie searches, music searches? Where does that take you? And I think if you step back and look at that, it is kind of weak, and you wonder why they thought that was worthwhile. Unless, hey, look, here's a search has cheating wives in it. Then he must have known about the affair. That in and of itself doesn't get me there. It just doesn't get me there. This is a sad dog story. Cocker Spaniel lived with a cone of ear infections. That cone, the cone of silence. It's a necessary evil, but it's brutal. And with this ear thing, as long as we're still talking about dog issues, you couldn't really do the cone because that didn't stop ears from flapping when he would shake his head. I guess it would contain all of the blood within the cone, but they have a special contraption that looks like a Batman headgear, where it goes down, it goes across the eyes like this and then down, kind of looks like, I used to kid that it looked like he was on Handmaid's Tale, because that's how it looked. And it pulls and it keeps the ears, tucked in. So he can shake like crazy and everything is kind of held in place, and that would allow the healing to take place. Then we kind of started trying to be preemptive about it. And we're putting, basically Neosporin type ointment on there 2 or 3 times a day so that it never gets a chance to dry out. So that's the turmoil about the doggies. So, okay. Some say we're in verdict watch. Some say we're in justice watch. But yes, we're watching. We definitely are. We're technically about a half an hour into the mix. I just want to go through a few more notes from today's activities and then leave you to your Friday afternoon. And obviously we'll pop back on when there's a verdict, and we'll be on. Linda will join tonight at 6 o'clock. We will go through some of these matters again for those that are doing the 9 to 5 and not able to watch this stuff unfold. Tyvek suit came up again. The Tyvek suit. I do think the conspiracy theorists are very interesting. I talked about this last night. See, this is the one I got. It's a medium. Probably could have gotten a large, but medium was fine. I'm at the top end of the. I like that they put height and weight on it, so you can get a sense of who's going to fit into it. I'm kind of at the top end of the medium, but they had no large. You go from medium to double XL. And people are saying, hey, he bought a medium Tyvek suit. That's because Mom, Diana Walshe, really is the one that was using it. Well, could have been just like what I found when I went there. Nothing but double XLs or medium. And I'm telling you, if you want to clean up a crime scene, you want to go with something a little more firm, tight fitting. You don't want a big old floppy double XL to deal with. So, no evidence. The affair, yeah, he really kept circling back to that. No evidence that Walshe knew about the affair. To me, that is key. There is evidence that remember that the New Year's Eve thing kind of cuts both ways on a couple of fronts. The party, as we were calling it before I knew it, was like 3 people, and it was just Jim, Anna, Brian, and then one of the kids popped down at some point. That was it. It was kind of just a nice little family gathering. But during that, the photo took place it was Jem and Anna, and then the little kid popped in there, and they wanted to send that to the boyfriend. Now, the Commonwealth wants you to believe that because they were so open and casual about that, Brian Walshe knew about the affair. I would think the opposite. I mean, first of all, there are people with, very open, liberal approaches to marriage, and I get it. You have to believe that's what's going on here, or he didn't know. It's got to be one or the other. And how could the Commonwealth, make a big deal of him not saying anything, then he knew because he didn't say anything? He knew because he didn't say anything, and he wasn't upset, and he was just, for the next 2+ hours after that photo was sent, he was still just, chumming it up with Jem and having, a relationship with his wife on New Year's Eve. They boiled it down to their comments on the box of the champagne. All of that stuff, to me, unless the jury finds he is a total psycho, it's possible. It's possible. That is some compartmentalization that I think would surprise a lot of people. It just would. What vibe did I get from Jem? That he wished he was anywhere else, but that he was so sad for the loss of his friend. Very hard to tell. I think if he was certain that Brian had done it, I think his testimony could have been altered slightly, because Anna's gone, the kid's not testifying. Brian, if he does testify, throw it in with the other issues he's got to deal with. If he's going to challenge something Jem said. If Jem wanted to make his testimony more damaging, he could have. And I don't think that he did. When he didn't, he could have said, remember the key problem, which led to many objections and many sidebars, was what did Anna say specifically about, her interaction with Brian and marital problems. That was his interpretation, but he couldn't remember the exact words. He could have made it up. If he wanted to just stick it to Brian, if he's sitting there and he's looking at this guy 15 feet away that he believes killed his good friend and business partner, former business partner, He could have. He could have said, yeah, Anna told me that she was afraid that Brian learned about the affair and that he did this and he said this and now he's done that. He had the opportunity to do that. But he came across as an honest guy who lost a dear friend, was somewhat confused about what happened, but was not going to bag on Brian because he didn't know the things that the Commonwealth really wished he did and wished he could testify to. So seemed like a nice guy. And I felt sorry for him a little bit when we were pursuing him, trying to interview him. And he was not interested. And that's a weird scenario for both, I think for both the media. I don't like to get that, reputation as just like you're part of this pack that's chasing somebody down. But you have people that were honestly curious about what he wanted to say or not say, gave him the opportunity to say or not say it, and then, basically stopped, and he felt he had to, continue running to get away. So I think it's just because it's a weird situation to be in, probably a little intimidating, maybe a little frightening, but he seemed like a very down-to-earth guy, not a cocky guy, just a guy who wishes he hadn't lost a friend and wants to get the hell out of there as soon as he can, which he did. Let's see. The planning that was talked about by Mr. Tipton. All of these bits of evidence that suggest that Anna and Brian had plans for the future. Remember, they sold the one property. They're doing an exchange so they could delay tax liability. They're doing that 1031 exchange, and they're working. I mean, I just don't know. Again, unless you're just a psycho and you can compartmentalize these things like regular life. We're going to continue. We're doing this, this, and this. And oh, by the way, on the other part of my brain, I'm going to be killing you at the first opportunity. It's hard for, I think, normal people to conceptualize that, to think that that's okay or that it's even possible. But that's what you have to find in this case, because they're doing all these things that suggest a future going forward. And if you look at even Alyssa Kirby's testimony about how she felt that Anna was very upset, very upset. The upset seemed to be primarily because she couldn't be with her kids. Why? Because Brian couldn't relocate because he's, house arrest at the moment and going to prison. That seemed to me to be the specifics that were talked about in terms of upset, not Brian's a dick, he's being horrible to me. Most of the evidence suggests, this guy's being Mr. Mom, right up to the time he wasn't. And I think there's just more evidence that her concerns, Anna's concerns, were based on what Brian could or couldn't do and how it affected her ability to be with her kids. That's the state of the evidence. There may be some evidence somewhere that she was going to take the kids. This is the kind of stuff, this is the Adelson scenario, that she's going to take the kids from New York, Boston, and she's going to move them down to DC with her. She's already got a townhouse, got 3 bedrooms in it, remember, all set up for the kids. But there's no evidence of that. If there were evidence of that, I'd be leaning Adelson on this thing. I'd be thinking, this is definite motive to get rid of Dan Markel in that case. He doesn't want the kids to be moved away. And that was already at post-divorce. Here, we haven't even gotten to the divorce stage yet. So I have a real problem taking the nuggets of info that are currently in evidence and creating intent to murder out of that chunk. Let's see. We talked about asset protection. We talked about the champagne wine bottle box, which to me is, I don't know, even if you suggest there's some problem with, thank you, Kay Schmidt. Appreciate that. Gifting 5 Justice Reserve memberships. May you get one, those who have not gotten one as a subscriber. May you subscribe so that you might get one. Would she write on that champagne box what she did if, which was basically, look at us, tough, I can't remember the adjective, but quite a year, and we're still here. Certainly at least a veiled reference to the challenges that she and Brian have had, and Jem was there as probably a confidant as well. Do you write all of that if you were having such an issue with your husband that you're on the verge of divorce. I don't know. Why would you say anything? Or why wouldn't you just like sign it, best wishes, or, you know, Happy New Year, 2023. She wrote a very detailed, thoughtful message on that champagne bottle, box, I should say. So it's, again, you know, the discord that you would expect to see, I just don't see it. Travel issue, again, that's what I think was worst. And Commonwealth tried to make it sound like, well, you know, she went on this weird Thanksgiving overseas trip, clearly with the boyfriend, and that Brian was upset about her not being around for Thanksgiving. Makes perfect sense. I think most of us were saying, wow, she didn't want to be with her family and the kids on Thanksgiving. But it doesn't go much further than that to kind of link those pieces together. I do think in the Commonwealth's argument, I want to get some of they did make points. Again, we're talking opposite ends of the spectrum in terms of presentation. I did time her, Ms. Asa, and she went, I mean, Yaz, Anna Yaz. She went 20, where did I put that here? I actually did around that. She did 33 minutes, Anna Yaz. So, but, you know, book tied, very much in the binder. You know, a little more emotive than she was when she was handling witnesses, right? But still, you know, a flat line, really, by comparison, a flat line. That's, you know, sometimes it's personality, sometimes it's experience. She maybe just hasn't had a chance to do as many, and maybe some people are kind of confused that Greg Connor, who was clearly lead counsel, he didn't do the closing. My dog will get that if water gets in her ear. You know, where you mean the shaking thing? Yeah. Dogs, crazy dogs. Yeah, it's you know, it's like, you know, even my son and a lot of people in the super dry weather, you know, their nasal passages get all dried up, and you get nosebleeds from that as well. So moisture is good. That's why when people move to, for example, Arizona, you know, you can really. Is he shaking his head so bad he's getting a blood lymphoma in his ear? No, I don't think so. These are truly, come here, let's show the people. No, it's the edge of the very fine edge of the ear, just, you know, drying out and getting a little slit in it, little teeny crack. So I think we're handling it now as best we can be. Looking at some of your notes here. You guys are very helpful to one another. I appreciate that. I like to see how you guys are asking and answering. If you do have questions, because I don't see these things as they fly by for the most part, yeah, put some big question marks on there or something, and then I or Missy can throw it in the starred category so that we can have a conversation about it. Let's see what charge we're talking about. Oh, there's one. I found one, but the question's on it. Will Brian serve federal charges first? Will they run concurrent to the state, or how will it be consecutive? I feel this judge will run other two charges concurrent. Yeah, and on that front, you'll remember that Judge Fenner did not sentence on the other two that he's pled to. That's the disinterment, and I pulled that statute, which we can share at some point. But it's written in like 3 parts, and it describes disinterment as what you would imagine, like unearthing somebody, but also carrying away of a body. And it's not necessarily conjunctive. It's not like it's digging up, carrying away. It's an or. So that's what part of the statute he's pled guilty to, that part of the disinterment, because otherwise it's weird, doesn't make sense. But she said, I'm not going to sentence on those until we get a verdict in this case, because it will impact the sentencing. If you look at the sentencing guidelines for that top charge, and also for the lying. Remember, this is interesting if you're totally into the weeds on this stuff. The third charge, really in terms of severity, is the lying to police. Well, if you're lying to police to cover up a murder, the potential sentence for that lying is greater than if you're lying to police to cover up, for example, disposing of the body, or you're lying to police to cover up jaywalking. The sentence will fluctuate. And so she wanted to wait and see if there's a conviction on the murder charge. She will then factor that into the sentencing for the lying to police. So I think that was very interesting. And she also talked about victim impact statements. We heard a little bit about the kids now with the children, what do they call it? Family Services. Everybody has a different little acronym for it. But the Department of Family Services They're putting together a report, which is basically an impact statement. The children, of course, will be not talked about. In fact, most of that will be sealed. I think they're impounding that report, but the court will see it to help reflect on the sentencing. And there may be other family members, Anna Walshe family members, that want to discuss the second charge. The lying to police, again, it'll depend on to which charge it relates. If it's to the higher charge, maybe it's different victim impact statements. It's different. To get back to your question, though, about federal charges, generally they would, because that's a done deal. He's got 37 months in that case, plus a hefty restitution bill of $475K. So normally that would be the way it works. You get the club fed, and then there are ways everything can be negotiated. I don't see it in this case because of the nature of the crime. If he, in fact, is found guilty of murder, I think there's not a chance that there's going to be any concurrency between the federal and the state murder charge. If he's acquitted, could be a little more ability to massage the numbers. But the federal crime, and they usually do 85%. And the feds, they are very, very popular with months instead of years. So obviously 37 months is 3 years and a month. But what's 85% of that? Let me just check. Anybody else beat me to that? It's roughly 31 years. 31 months. Sorry, 31 months. So he's going to do at least 2.5 years on the federal stretch. Then he could go to state prison for the rest of his life. So enjoy the Fed time while you can, sir. Because no matter what happens, you're then going to be sentenced on the other two, which now the disinterment, I thought I had this handy somewhere. I should pull it up. The disinterment is not as bad as you think in terms of a penalty. It was 4 years, I think was the max, and I think a fine of $5,000, something like that. Let me see if, even if I can't share it with you, I can remind myself by looking at it here, because I'm pretty sure I did something with it. Here's how it's described. This is Massachusetts General Law 272, paragraph or section 71, disinterment of dead bodies. Remember, he was not convicted of the murder. That's up for grabs right now, or the dismemberment. That didn't happen either. Willfully, here's the way it's described. Willfully digging up, disinterring, removing, or conveying away human remains, or knowingly aiding in such acts. So that's basically, that third part of it is what relates to this case. Conveying away human remains. Penalty, up to 3 years in prison and $4,000 fine. I was close on both of those. So that's it's a weird statute because it's technically, it's a grave robber type statute. So that's not much. So that's why the judge is so concerned about the sentencing on the lying, because it could be far greater than the sentence on the disinterment. So he could, if he's not found guilty of the murder, then he could do 20 plus years, depending on what she sentences him to on the lying. So it's huge. This is true. The first federal charge, second state charge, I think they're all, yes, everybody's all separated out here. Federal court's done effectively, and the obvious state court, we know what's happening with Judge Frenier there. Okay, so I can see how this gets a little wacky here. The art federal charge, yep, because it was interstate, yep, and it was online, so it's an international type crime, meaning intent to have or hold the art across state lines. Yep, that's all true, all true. That's why one's a federal crime and one's a state crime. Okay, Darcy, yep, I've got 45 minutes, so it's been probably 48-ish or so. Again, we are now in what has been, during the course of this trial, their lunch hour. So poor Diana Walshe has gotten a bad rap in this case. People think she's in on it somehow. And again, you start to get Adelson vibes in terms of, mommy dearest, but there's just not enough evidence, not even close to enough evidence to drag her into into the mix. And I was not intimidating her under the Massachusetts statute. And fact is, she wasn't a witness ultimately. So there you go. Okay, let me see a couple more notes here. I do think they have a good argument about the timing of the contact Brian attempted to make, either by phone call or by Google search, to learn about Billy Fastow, because this happened. Let me double check the timing as they reported it here. It was just after Christmas, right? And that was the day in which, I mean, who doesn't know what happened on Christmas? Here's what happened on Christmas. She missed that morning flight. Why? She's kind of hanging out with her boyfriend, lover the night before. Maybe he slept in, maybe whatever reason. I can just picture that. That's how she blows the flight. Then can't get on another one because they're all booked and canceled. And so she ends up driving. So he's pissed off about that. And I understand that. And whether it's because he thinks she was with somebody else or just in general, works too much and she's going to be late and her kids are here, that she gets home at 8 o'clock. And, these are young kids. They're all in bed, most of them, by just after 8 o'clock. But I think it was a good point they made, that after that discussion that they had, that he looks up William Fastow. He does a little Google searching. Well, why would he do that? Is now what he understands that to be a crush, maybe it's developed beyond that. So I think that was a very good point for the Commonwealth. It's one of the few, to me, ideas the jury can take and from that infer that he did know or he learned soon after. And that was just after Christmas. So there were still a few days for him to do further investigation, and nothing that was brought into the trial as evidence. But reality, yeah, that's exactly what could have happened. And then that all boils over on New Year's Eve. They talked about the purchases that to me mean nothing. You mentioned all of the things that were purchased, right? The hatchet, the trash cans, but all of that goes to disposal of the body, which we know is not an issue here. And the court has told this jury, you can't take that information, whatever you make of it, and create intent from that. You can't do it. And I think the Nightshade reservation was very interesting. Remember, there's a Nightshade reservation that was deleted from the phone at 7:59 the morning after. So on the 1st, that was the day they were going to go to this lovely dinner. But apparently the reservation was no longer needed. Well, why was that? Was it because she disappeared, because he disappeared her, or was the setting up of the reservation just a ruse, just to make it look like, see, everything's all lovey-dovey. We're going to dinner. If that's the case, why would you delete it? I mean, what's the purpose of deleting it? Makes no sense. And that, of course, again, a good point for the Commonwealth. This was during a time in which the phone was lost. The iPhone 13 mini, the one connected to Brian Walshe, that was missing, according to Brian Walshe, but it was also locked and unlocked a number of times during that period of time. Very suspicious. That, to me, is some of the better pre-disappearance, pre-murder evidence against Brian Walshe. Those things, you can't really, to me, square those with some claim that he either didn't know about the affair or didn't have some reason to confront Anna. Okay, and then we talked about the victim impact statements that are going to be coming up, and then the final instructions. Again, appreciate Franieri splitting those instructions up. I think it's a great idea. Talks about guys got to be unanimous. Sentencing, don't worry about it. Don't worry about it. It's not your job. Now, let's see. Not holding against Walshe any of these other issues that including his not testifying. You can't hold that against him. Look at the credibility of the witnesses. This is one of these trials where I don't think there was a huge issue with credibility, right? I mean, we know Guarino, anybody on the Massachusetts State Police, you may not trust just inherently, but it's not like there were a lot of people confronted with lies and misleading statements. It was pretty clean on that front. So witness credibility, again, I don't see as a big deal in this case. Trash bag picks, that's where the judge said, some of these are graphic. Well, they're really not, but what your brain does with that information makes it graphic. Gave them the example, classic direct versus circumstantial evidence. She decided in the charge conference that she was going to use the word indirect, saying direct or circumstantial, also known as indirect evidence. I don't know. Do they not know what circumstantial evidence is now that they feel more comfortable calling it indirect? I don't know. I really don't know. Okay, I like this. Mary Moynihan Connolly, if he didn't know for sure about the affair, I think he did have a strong suspicion. His mom hired the PI, and don't forget she went to a shrink. He called the guy, Googled him, as I was just saying. Brian had access to bills showing her flights, which relates to the trip to Europe. All of that, I agree. There's stuff, there's something, but I don't know if it gets me where I need to go. So I appreciate that analysis, though. And the jury could be making that exact same analysis. I keep getting these phone calls from who knows whom. That's a good question. If I were psychic, I would know, Brooklyn, what the psychic says now, but I don't. I have no idea. Psychics. I will tell you, it's a radio commercial, and it's for some psychic network of some sort. I remember back in the day. Remember Miss was it Chloe? Is that what it was? Miss Chloe? Is that right? I should know because I spent time freaking tracking her down. I'm in Florida where she lived, and we learned where she lived. This was when I was with, well, of course, A Current Affair. What kind of show would be tracking down a psychic? So I go down there. I'm on the ground in Florida, and I'm trying to find out where she lives. I'm knocking on the door. It's in kind of rural Florida, like bad things could happen there. But I never found her. Spent plenty of time looking, but obviously she was psychic, knew I was looking for her. And so I was unsuccessful. So there's a commercial, though, a series of commercials that I actually like, where they talk about life changes and challenges, and they have this little sound effect or music theme that is just almost haunting, but in a playful way. I would try to simulate it, but I would do no justice to it. But I was impressed with, let's just face it. I believe psychic interpretation is sort of a desperate move. It's like, I need some help from anybody, somebody, give me something. I'm a little bit of a skeptic about it, right? But these commercials, I think, make it sound like, yeah, it's not a bad option. Give it a try. So kudos for those folks. Okay, well, Carlene has no question. She's positive he knew. So if he knew, Carlene, was he planning to off her, or did it just evolve when there was a confrontation? Because that's a huge difference between, intentional, premeditated murder and some sort of passion, So think about that. Okay, one more thing. I want to look at one more thing on the judge's notes before we wrap it up and begin our own deliberations, which may mean have some lunch. The consciousness of guilt, so important for this case because it gets people in the jury to intent. Why are you doing things because you feel guilty? Well, what did you do to get you there? So it's an inverse way to get to the motive, and of course get you to intent. So consider defendant's actions, but you have to consider there may be an innocent reason for the person to act as they did. It's not always a guilty conscience. The defense would want you to believe it's shock and just fright, and he had no idea that if my wife just dies, I should call 911. I mean, that's a big hurdle to get over for a lot of folks. But the judge is reminding them, look, something that looks like consciousness of guilt may not be. So open your mind, Impeachment, talked about the bad acts, and these were the four things she specifically talked to the parties about yesterday. The bad acts include the art fraud, lying to police, disposing of a body, and lying to the probation officer. And you can't use any of that to consider murder. Can't do it. Some tips she gave him at the end: slow down, take your time. Again, no real straw polls, and don't disclose your deliberations. Don't do it. And this was something that happened when I was covering a case in Savannah, Georgia. And the way that we did it at Court TV was, and I think they still do it this way, even though it's a totally different operation. They would assign the correspondent to a given trial. And so you're the one for that. And so I went down there, was doing this trial in Savannah, which is a lovely place, great place to be for for, I think it was probably 2 weeks for sure. And the beautiful thing about Court TV back then, back when they weren't afraid to spend money, they would fly us home every weekend. It was cool. You know, sometimes you have the family come down. If you're in a place like Savannah, you know, bring them down and enjoy, you know, the community that you're getting to experience in a weird, bizarre way, true crime. But it was so cool. You could just, if, you know, I was in some nasty places, I'm like, can I please get out of here on a Friday night? And they were doing it, but those things don't happen anymore. So I was on this case in Savannah, and the jury was deliberating, and I had some sources very close to the process. That's all I could say. Didn't disclose it then, ain't disclosing it now. But I learned during the course of deliberation, and this was a case that was pretty hotly contested. It wasn't a slam dunk in any way. And I learned that the jury was evenly divided. That's, I think, how I described it. I then went to, you know, interpreted that to mean, you know, something like maybe if not 6-6, you know, maybe it's 8-4, maybe, you know, something that indicated it wasn't a lone wolf standing out. Well, the judge was watching the broadcast at the time, calls me in open court, chastises me, and says that I'm, you know, breaking some sort of rules, violating some sort of confidences. And of course, I did not disclose my source. I said, I'm just reporting what we're hearing. You know, I'm not wearing a robe. I'm not an officer of this court. So I'm just reporting what I'm hearing. The audience can take it. They can leave it. It's not going to, and you think the jurors are in there watching TV? I mean, where's your concern? Okay. Is the control over your jury so loose that you think somebody on court TV saying something about what they've heard is going to impact the jury? I understand avoiding the perception, you know, any sort of perception of impropriety. I get that. I was just reporting what I heard. That's it. Anyway, so they yanked me out of Savannah, and I was not there to take the verdict. In fact, ironically, Savannah Guthrie, who's now at NBC, of course, went to Savannah, and she took the verdict, and I was back in the New York studios to comment on, because I knew the case. I was the expert on the case, and it was just weird to parachute her in, as I've said, and replace me. But, you know, the network, they get all skittish. Ooh, what's going to happen? Yeah, do what you need, Judge. But I was not breaking any laws. I wasn't violating any court rules. I was simply reporting. And sometimes, you know, First Amendment pisses people off. What can I tell you? Okay, so that is in relation to the judge saying, you know, don't talk about your deliberations. And if it carries over, as she said, you know, we end today and it's still going, don't talk about it over the weekend. Don't do it. So my homework assignment now, between now and when we get together again at 6, and Linda Baden joins, is I got to see if I can get a better idea of how they numbered those seats, 1 through 8, 9 through 16, or was it the inverse or whatever? Because then I can put that information into my little checklist here, and we can talk specifically about who is left on the jury, who the alts are, and of course who the foreperson is. So let me get on that. Okay. Let me check one last time. Anything happening here? Oh, no. In fact, I'm glad somebody's reminded me. I forgot to post the poll. I'm going to do that right now. And it's really just going to be, what do you think? You know, guilty, not guilty. In fact, I think I can do 4 on a YouTube poll. So maybe it'll be guilty of first degree, guilty of second degree, not guilty, hung jury. And I do like how in the verdict form, thank God, a verdict form or verdict slip, as they say in Massachusetts, that makes sense. You know, it's not all convoluted, very simple. And the top option is not guilty. That should be the top option. Why? Because you're presumed not guilty. So that should be the top charge or top option. And then murder 1, murder 2, and then you're done. Simple, right? It's never simple. But I appreciate that, Dizzy. I'm going to sign off now and put that up on our page. Then I'm going to try and figure out the sequential ordering of the jury so we can get some detail on that based on my having seen them over a number of days. Okay. Hey, thanks for joining this morning. Appreciate it. You know, will we have a verdict today? Will they sit on it over the weekend? Is there going to be a holdout or 2 that just doesn't see intent? I would be the holdout. I would be the jerk. I'd be the idiot that they'd be trying to put in a headlock and pummel me into submission. But I don't see intent for either first or second degree. So there you go. All right. See you tonight. In the meantime, try to do the right thing.
Riding flames, they charge with mine.